Good morning to all. We welcome all the participants on behalf of the Impressionz 21 team to our event suits, and we are happy to have you here. We would now like to introduce our judge of the day, Keshav. Keshav, an alumnus of Vidya Mandir, is a second-year law student of OP Jindal Global University. Having placed in various poetry events such as AdsApp, Whose Line Is It Anyway, and Channel Surfing, Keshav has his own knack around poetry events. He is an avid jammer, quizzer, munner, debater, whose passion is in argumentation is unrivaled. Keshav currently works as a research assistant to Professor Sandrine Dehert from Belgium in international maritime law. Having always been an engrossed participant and a finalist in various lawyer events, we are happy to welcome him here as a judge for Impressionz 21. Now, Keshav will introduce himself and tell all the rules to you. Thank you. Keshav,
Hi,
take
thank
over.
you so much, Varun, and I hope all of you are having a great morning. Varun, just one question. Would you be screen sharing the rules as I explain them later?
Yeah, that can be done. Just give me a moment.
Okay, all right. Welcome to Impressionz 2021, and this is your event lawyer up. I'll be serving as your judge today. Just to know, before you have any stress or anything, just make sure that just understand this is an event that's happening at a culturals, and it doesn't like test your predetermined knowledge about the law or so forth. It's basically about testing your spontaneous logical reasoning and how you present your arguments. And at the end of the day, it's going to be a fun event where you just have to be smart and think on your feet. All right. Before that, have the event organizers taken attendance of all the participants who are coming today?
Yes.
Okay, so we have all the participants, right? Just no confusion on that.
No, there'll be one participant who will be joining late because he's caught up in another event at the same time.
All right,
Other than
that's
that,
no issue.
yeah.
All right, okay. So with that being said, I'm not going to waste any more time on all these niceties because I'm sure all of you are pretty curious or engrossed to go into the event. So let's just do that. So firstly, I'll be explaining the rules, and after I start explaining the rules, if you have any question, just please raise your hand. I can just ask you about it. All right? Okay. So the rules, as I said earlier, it's pretty simple. All of you, both of there are two individuals in the event. One will be the plaintiff, one will be the defendant. And the plaintiff will be you will tell you who is for and who is against. The person who's for will be the plaintiff, person who's against will be the defendant in simple terms. So we're going to have two rounds. Firstly will be the opening round where we'll have first preparation round where you'll be given around 3 minutes where you can prepare your case for presenting your case, and secondly you'll be given 90 seconds to give your speech on why your client is correct or whatsoever. And thirdly, I'll be allowed to ask 3 questions to your other participants, and where you have to answer the same and vice versa. It's a pretty simple event. If you have any questions, just let me know now. I think you'll get it easier when more participants participate in the event. But if you have any questions, just let me know right now.
The cross question is just the other participant, right? And not you questioning us.
No. It's just the other part. So let's say you and I are participating in this event. After you give your speech, after I give my speech, I could just ask you I can ask you one question or just up to 3 questions, and they could ask you 3 questions once you're done with your speech. That's it. Any other questions? Any other doubts? Anything really?
Can we present any witnesses, or is it compulsory to provide any witness or something like that?
There's no usage of witnesses and so on. Let's just say, okay, I'm just going to give you a case, right? Person A slaps person B. Your person's B's lawyer, and you're taken to court and why he slapped me. You give the reasons for person B, why he slapped him, why it's justified for him to slap him. And person A's lawyer will be just saying why wasn't it justified for him to slap him and why it was wrong. That's literally it, except you're going to have this more complex case scenarios. All right? It's really not that big of a deal. It's actually a very fun, like back at like school, at least like at lunch breaks and stuff, we just used to play this event randomly at times, come up with case scenarios and so on. Okay, so any other questions? Because it'll be, yeah.
Yeah, I have one. Will the creation of implied facts be allowed?
What do you mean?
Like implicable facts, right? So if there is a already existing fact, I just derive a fact out of that fact.
To a certain extent, we can allow interpretation, but not really more. Like, I'm going back to the thing where slapping the person, right? You can't say that he has a mental condition where he slaps back every person because of nervous system problem. You can't really do that. You can just interpret the facts of the case to a certain extent to your benefit.
All right, cool. So, so you mean to say that I can say that there might have been something going on between them, and that is why the person
Yeah,
may have slapped person. I
yeah,
can say that, right?
you can say that.
All right, cool. Thanks.
Cool. Do we have any more questions? All right, okay. I'm just gonna wait for a minute for you guys see the rules and just like sink in the event and stuff. Before that, Varun, would you be screen sharing the list? Unless,
Yeah,
or
I'll
you want
screen
me
share
to?
the list after the rules. Let them take a minute for the rules.
Yeah, cool, cool.
So these are the opponents will be going against. Participant 1 will be for and participant 2 will be against. So for example, the first team will be Manan S. Parke and VL Sai Mehta. So for the case will be Manan and against will be Sai. Okay, that's the case can go through. This they can start the event in 2 minutes.
Also, Varun, the cases. Do you want
I'll
me
send the cases one by one in the chat column as we go on.
Good. Sounds good.
Is this the order we'll be participating in?
Yes. So in case someone has any technical issues and they're not in the meeting, we will move on to the next pair and come to them in the last.
Okay, thank you.
Is everyone fine? Can we go over to the event?
Yeah,
I just have a doubt. This is Sanyukta here. I'm a first comer,
Yeah,
so
okay.
can I go to the next round? Is that fine?
Yeah, sure.
Thank you.
Yeah. Case of 4 people are yet to join, so we can move ahead without them and they can join.
Are they in the first few rounds?
No, they're in between. It's fine. We can go.
After you can tell them. I can if okay, fine. Yeah. Just tell any of the participants if they have any questions, just to make sure they ask before they participate, right? Before their names get called out. Because during the round, like between, I can't entertain any queries and for the participants alone. All right.
Yeah, okay. I can message them. Yeah, thank you.
Cool.
Okay.
Just give them 2 more minutes, then we can start.
Yeah, sure.
Cool.
So when we are, I have a doubt actually.
Yeah, please tell me.
Yeah, go.
So when we are referring to some law, we should make sure that it actually exists, right? So, if the year is not a bit accurate, will that be okay?
I really don't expect you to refer to laws, so please don't just mention the law. It's all right.
Yeah,
Because
cool.
we don't expect all of you to know legal jargon, legal knowledge. We're considering all of you are 16 and 17-year-olds in high school, so it's all right.
So I have one last query. Then is it like we only need logical knowledge towards the case and not more deep legal knowledge towards it. Am I right?
Yes. But you can, if you do possess certain legal jargon, you can feel free to use them. But the more emphasis for marking and presenting it will be your argumentative skills. Gotcha.
Okay, fine. Thank you.
Hello, my name is Nandita. I have a doubt.
Yeah.
So we can address you informally, right? So we don't need to.
Yeah. Call me
Yeah.
Keshav. Don't call me sir or anything. But yeah.
Yeah. All right. Thank you.
Yeah. Just please don't. I mean, I've been in lawyer up events. They usually ask, like, call the judge your honor, and please just don't do that. Yeah.
All right. Thank you so much.
I have a habit of referring to every single judge as the panel, so it's
Cool.
okay, right?
Works.
Okay, cool.
Keshav, are you ready?
Yeah, I'm ready. The cases. Do you want to read it out?
Yeah. 1 second.
Put
The
it on the
first.
chat box to may help. Send it privately to them on chat.
Okay. The first two people will be going up are Shakti Palaniswamy and Niranjana Nadesan. Shakti will be for and Niranjana will be against. I will send case files. I sent them the case files. They're 3 minutes for prep starts now.
Wait, 1 second. Can we read out the case? If they have any query,
Yeah,
they
sure.
can ask as well.
Okay.
If you feel free to read it out.
Okay. A teen commits suicide. Upon going through her internet history, parents find out that she has been seeing a lot of suicide-related articles, videos, etc.
I have a
There was
doubt.
especially.
I'm
Yeah.
so sorry for interrupting, but will
No,
we begin a separate case for everyone or same case for everyone?
different cases for every.
Okay.
Different cases for everyone.
Sorry. There was especially one video on YouTube which the teen had been repeatedly watching. The video was a spoof about how to commit suicide, why one must commit suicide, etc. The parents sue YouTube by publishing such disturbing content. Their daughter was pushed to suicide and thus assisted her suicide.
Okay. Now who's for and who's against?
For is
Shakti.
Shakti and against is Niranjana.
Okay. So Shakti, you would be the plaintiff. That is you're the person. You'd be the parents. You'd be advocating the parents' interest, and Niranjana would be YouTube, right? You'd be representing YouTube in this. Do you have any questions, Shakti or Niranjana?
No. No.
Okay, cool. Your time starts now.
1 more minute left. Time is up. So the students who are participating have to have their videos on at all times. Just
All right. Okay. So I hope the participants are ready. So I'm just going to say this one more time. Welcome to Impressionz 2021, which is the event Lawyer Up, and I'll be serving as your judge or whatever you like to call it. I prefer the name Keshav. You can call me anything you want. But yeah, so as I said earlier, Lawyer Up is one of the few events that is intellectually challenging for students in a social space like culturals, where we have like mostly in events related or intertwined or humor. So please make sure that you just think on your speech spontaneously, logically reason out your arguments and present them in a neat manner. And we'll be only marking you on both those metrics. So with that being said, would the participants want us to screen share the timer like for 90 seconds, or is that if I just tap at like 60 seconds, it's all right?
It would be great if you could like screen share so that I know how to
Okay.
manage time.
Pranav, is it possible for you to screen share the timer? Varun, is it possible to screen share the timer?
yeah, I'll just check once.
Also, I have like a doubt. I'm
Yeah.
really sorry I didn't ask it earlier.
No problem.
So in the cross questioning time, does the plaintiff go first or the defendant go first in questioning?
Plaintiff. It's all right. Plaintiff, defendant, plaintiff, defendant.
Timer for how many minutes? Sorry.
90 seconds.
90 seconds. Okay. Can I start?
1 second. I'm just going to read out the case again. So the case is okay. So a teen commits suicide. I'm just going to say it for all the participants who's watching this. A teen commits suicide. Upon going through her internet history, parents find out that she has been seeing a lot of suicide-related articles, videos, etc. There was especially one video on YouTube which the teen has repeatedly been watching. This video is actually a spoof or a parody about how to commit suicide, why one must commit suicide, etc. The parents sue YouTube by publishing such disturbing content. Their daughter was pushed to suicide as assisted in her suicide. Now, Shakti will be speaking for her parents and Niranjan will be speaking for YouTube. Shakti, whenever you're ready.
Can I start?
Yeah, you can start. I'm starting the time.
Yeah, thank you. Thank you, panel, for this opportunity. First off, I would like to start with the basic statement that every parent in this world supports for. The internet is a dangerous place. We've been teaching this sentence to our kids since we gave them the access to internet. Since we gave them access to internet because they wanted it for school, for assignments, for research, to encourage them to dive deeper into the knowledge that is available on the internet. But the internet also has a darker side. It's not like the parents just ignore it and only talk about flowers. We also tell them how dangerous the internet can be. We talk with our teens, we talk with them about what it is and how you have to stay away from them. I would like to point out that my client and her daughter had a very good relationship. They always talked about what they wanted to talk about and everything that the teen was going through. The relationship between the parents and the teen were very good, and there was nothing that the parent did not know about the teen, or that is what they thought. But YouTube being a platform which promises their clients to give them only the content that they need, YouTube having a claiming to have a very good community policy has failed repeatedly to ban unwanted content such as suicide and self-harm. YouTube has done this many times, and many cases in the past have come against YouTube on not banning needed harmful content. And their community policies that follow on voluntary basis of reporting does not work. With that, I rest my case on how YouTube has failed their clients on protecting them against self-harm or harmful videos.
Thank you so much, plaintiffs. Defendant, whenever you're ready.
Okay, so according to me, I would just like to point out the definition of suicide. Suicide is considered to be a death caused by an injury to oneself with the intent of getting killed. So basically, whoever is going to commit suicide already has the idea that they want to kill themselves. So nothing such as a small video or anything can provoke that kind of a mental instinct to commit suicide. And second thing, there are many reasons. So I think my opponent said that they had a good relationship. So if they had a good relationship, I think the parents, it was the duty of the parent to find out the reason where they're depressed or where they're stressed. It was necessary for the parent to find out. And second, there is a difference between viewing and following. I can view something, but I need not follow it. And one must view only certain things that they feel they are mentally capable of not affecting themselves. Also, YouTube has very much good guidelines for demonetization for any content that is not appropriate. So there is a possibility that it was the creator's fault, or it is one of your client who would have used different, there are very different ways to look through demonetized videos as well. So that is one of the things. And another thing, if the parents were so good relationship, why did they not check the YouTube history or anything before committing suicide? Why do you want to take all these kinds of steps after the thing? So I feel like YouTube, and also if I am interested in crime doesn't mean I'm going to become a criminal. So there may be different reasons why your client may have committed suicide. Blaming it on YouTube is a very petty thing. And so I would like to rest my case saying YouTube will be no way responsible for the suicide of your client.
Thank you so much, Ms. Defendant. Now we'll be having the cross-questioning round, but first, the plaintiff can ask 3 questions to the defendant can ask 3 questions to the plaintiff, and then the plaintiff can ask 3 questions to the defendant. Okay, Niranjana, you can just ask a question, wait for her to answer, then ask your other 2 questions. All right? Okay, yeah.
So I clearly heard that you said that the parent and your client had a good relationship. That's what you thought. So what if you yourself have a doubt that it was what it thought? I'm pretty sure the parents also had that kind of a guilty conscience that something may be wrong. So why didn't your client's parents take an effort to get to know further by looking through the history if they had some kind of a doubt?
Thank you, defendant, for the question. I would like to point out the psychology of a teenager first. Do you really think a teenager comes out and talks to their parent that very easily? Or do you think the teenager has a mentality to stay strong and say, no, this is not how it is? They need parental guidelines. And the thing about teenage psychology also is that once you tell them that you are insecure about their ability and you go through their YouTube history or computer history or device history, is when the trust they have on their parents is broken, and that itself forms a very futile environment in the house. My plaintiffs, as what they have told me, and I quote, they wanted to have a truthful and trustworthy relationship with their daughter, who was at time a teenager. I would like
to need smaller answers.
Okay, sorry.
Yeah,
sorry,
it's all
right. Yeah, I would like to just emphasize.
Yeah, please go.
I'll just like to emphasize that my client's daughter was a teenager, and you have to take in account of the psychology of a teenager and the mental health that she possessed at that particular time. Thank you.
Defendant, your second question.
Just a small clarification. I'm extremely sorry. Are we allowed to give a counterpart, or is it only the questioning thing right now?
Just the question.
Okay, fine. So I would like to know, just you may say about the psychology, then if your psychology is like that, what was your definition of a good relationship? Is just good relationship getting things and all those stuff? What was your definition of good relationship? If you felt like it was psychology, it is insecurity, parents should not intrude, then that is not the definition of a good relationship in this society.
Question, please. Thank you.
Okay.
Thank you, Defendant, for that question. I will keep it short. From the answer of for the first question, that when I say that my client had a very good relationship with their daughter, I mean my client had active communication with their daughter, and they had known that there was something, they would have known there was something going on with their daughter, and they did take steps on identifying it. But then a teenager's mentality is extremely unstable, and understanding is beyond any parent's goal, because a teenager can be many things, and they can be influenced very, very, very easily. And that is what I think has happened in this case. The teenager was influenced very badly because of the videos that they saw on YouTube, which YouTube very poorly had not noticed and taken down with their community guidelines. Thank
you. Your last question, or if you have none, I could just ask her to proceed with her question.
Just one more question.
Okay.
If there was good communication, I'm pretty sure the parents knew the interests of the client. So generally, teenage, they express their interests in a very vocal way. So if their interest was on something harming, and I'm pretty sure then your client's parents would have known that, and they would have found out. Why did they not do so? Why was it too late from their side?
Thank you, Defendant, for the question. I quote you, teenagers are very vocal. I would like to object that point, considering how we have known how teenagers are the least vocal people on this planet. They think they know everything, and they do it because they just think that they know everything. They're adults now. They do things beyond a parent's control or knowledge. We all have been, assuming the points that we are not teenagers right now, we all have been in that part, and we have never ever included our parent in any of those thoughts. We always showed only like the flowers and gardens to our parents. We never wanted to show that part of us to our parents. And how can you expect Niranjana to do the same with her parents? And how can you expect the parents who loved her very much to know it beyond Niranjana? Because Niranjana, being a modern teen, has made it very, very hard for her parents to understand her, even when the parents want to understand her. Thank you for the question. Thank you, panel.
Thank you so much, Defendant Plaintiff. Now, Plaintiff, whenever you're ready, you can ask your 3 questions. Just know that it's not mandatory to ask 3 questions. Even 1 question or 2 can suffice. 3 questions is the hard limit.
Right? Okay, I'll ask 2 questions.
Yeah, anything works. But
yeah. YouTube has a community guideline which it requests the viewer to report the particular video. For a certain number of reports lead to the video being deleted, if I'm not wrong. And that is how YouTube's community guideline policy works. So videos such as self-harm, pornography, and then videos describing about depression and what a lot of other videos get reported on a voluntary basis of the viewers who watch that video. Am I right?
Sure.
So, okay, sure. Okay, that's a very uncertain answer. Moving on to my second question, considering how Niranjana was a teenager and had expressed interest in learning about content such as self-harm and suicide, how can you have the defendant has expressed many a times about how it was a very voluntary thing. Suicide was a very voluntary thing, and I would like to express about how Niranjana was a teenager and she had how can I say, slipped upon or just discovered it. And then if she had opened that video and she had watched that content, how does YouTube expect a teenager such as Niranjana or any other teenager, let's say Max or Sam at the United States, to report that video voluntarily when she expresses content on that video? And how can you expect that this voluntary reporting content process program or platform will lead to a safer YouTube community?
Okay, so first of all, I am able to understand first, YouTube algorithm works like nothing gets recommended on its own. Based on your interest, that's how your YouTube recommendation works. So why would your client want to go watch suicide or self-harm videos if they are not interested? I would not say interested. You said it's the psychology. So there may be various reasons. Either they are mentally, it is how suicide inducing some kind of a mental problem, or it may be due to influence. So how can you blame YouTube? You go and search up for things. It does not come to you on your own. So why would you want to go and watch it and then report it and then say that nothing has been taken? If you did not want to watch it or you were not interested in that, you don't even go to that. Why would you go and watch it and then report it? There is no need for you to do so. If you want to stay away, you better stay away, and you don't need to watch it. That is what I'd like to say.
Thank you for the answer,
Thank
Defendant.
you.
I'd like to use my last question because
Yeah,
I used to. Yeah,
sure.
sorry, I'm really sorry, panel. So YouTube says that the teenagers shouldn't have gone to that particular place of YouTube, right? But YouTube has emphasized a lot of times on how they aim or they work really hard to take down such content. So that means that they're blaming a teenager who is below the legal age on viewing a content, understanding their mentality, instead of taking the blame that they failed to take down a content that they should have taken down.
Okay, so I would like to say, I know the algorithm works. Like if it is an age restricted video, you need to sign in with some kind of details that gives your age. So why won't you take the responsibility that your client has put in a wrong age, because below 18, the content is not allowed. So there was a way in which this content has been made above 18 and your client has watched it. So if the parents are not able to look for why or how that has been done, YouTube has its policy. The reason it gives an age restriction is to prevent such things happening. If you are going to go behind the back and go to adult website, it is not the website's fault. Everything has something. The content is for the world. Everybody, those who are interested in few things will see. But having a tragedy unfortunately happen has no link to the website. There are so many people who still watch it. They're still alive. So it is something like self-confidence and self-restriction was necessary for the client if they knew that they were in such a vulnerable position.
Thank you so much, Varun. Varun, I'm just going to add one more rule to this, where the judge could ask a question to the participant.
Yeah, sure. Yeah.
I think that'll be easier for the thing. Okay, firstly, I would be going to the plaintiff. Firstly, as you're representing the family, right? Do you not think the family plays a major role in the viewership of a teenager in the internet?
I do believe that a family plays an important role in guiding or supervising a teenager's viewing history and everything. But then, considering how my client wanted to have an open relationship with her daughter, and then she emphasized a lot on how she gives her the freedom and trusts her. And she said she had a lot of conversations with her daughter and had restricted herself from invading her privacy, considering how invading a teenager's privacy could adversely affect their mental health. But yes, the family did play a very important role, and they did have talks with their daughters. They did have open communication with their daughter.
Okay. Definitely, just one more question to you. One question to you. Do you think YouTube's community guidelines are effective for like unauthorized users or like teenagers, though under the age limit, to see these videos? Do you think it needs to improve on that? It's a question.
It needs to improve, but the rate of YouTube's community guidelines failing and causing this kind of tragedy is very less as compared to what it actually benefits people.
Okay.
There is always a room for improvement in any case, even in the communication of the parents as well as that of YouTube guidelines.
Okay. Thank you so much, Shakti and Niranjana. That concludes the first round for this thing. Secondly, we have you can please switch on your camera. We'll be telling you the finalists after everyone's done with the first rounds. So Varun, we could call upon the next participants.
Yes. So next it will be Vannan S. Parak and
you could
Sai
share your
Sundar,
screen, it would be great. I think.
Yeah, 1 second. Okay.
Can I ask a question?
Yeah, please go ahead.
Am I allowed to, from the case study given, am I allowed to make up a fact, such as for the previous
No,
case
you
study?
have to stick to the facts of the case.
No, for like the example being for the previous case study, you said that the girl was a teenager. Can I assume the girl's above 18 or below 18?
No, if by looking at normal circumstances, teenager, we will be looking at under 18, under normal circumstances.
Okay.
Also, it was mentioned a teen commits suicide. So that's why I got the fact that it was a teen. It was not self-realized fact.
18 and 19 are also teenagers.
Okay.
Okay. So like
Thank you so much. But yeah, now it will be Manan S. Parekh, right?
Yep.
Yes,
Varun?
and VL Samita.
Okay, both of them here.
Yeah.
Yeah, can you see me?
I'm 1 second. I just stick to gallery. Yeah, all right. Are both participants here?
Yeah. Can you see me?
Yeah, all right. Okay. So Varun, if Varun, if
Yeah,
you could just
I'll
send
say,
the case to them.
sorry.
Okay, fine. Okay, Tarun, you can go after this, if that's all right. Cool.
Keshav,
Yeah.
Tarun has an event after this, it seems. So we can do
Yeah,
Tarun
after this
first.
round, maybe he can go.
Okay, sure, that's fine.
Cool. Yeah. Varun, could you please send the cases to them?
Yes, I'll say.
Varun, could you, well, if you've sent the cases, just tell me when you send the case so you could start the timer.
Yeah, I just sent the case. Start the timer.
You could put the case, like, okay, if you could just send me that, if you could tell me, if you could read out the case, I could copy paste the case, fact of the case in the Zoom chat as well.
Oh, if you want, I can put in the chat, like everyone's chat. So DMing each
Yeah,
one and
cool.
everyone.
Exactly. Because we also know there are viewerships to this event.
Okay.
Cool. Okay. So the time starts now. You're timing them, right?
Yes, we are.
Who is the prosecutor? Who's the plaintiff and who's the defendant?
So
Screen in the
for
Excel.
will be Manan and against will be Samita.
Oh yeah, right. Okay, cool.
Yeah, thank you.
Okay. So wait, Manan will be the plaintiff, right?
Yes, he'll be for
Who's for the case?
Manan.
Okay, so Manan would be the person who's suing the case, so that he would be representing sub G, and the other person would be the government of Atlantis. Varun, just one quick thing. Desakti has asked this question. So I just wanted to ask that maybe in the cross-questioning round, we could send the participants who are to come next the facts of the case, so that it will fasten things for us. Is that possible, or would that be hard? Because you have to also prepare.
Can you repeat that? And get you.
At the time of cross-questioning for the participants, would it be possible for you to send the next facts of the case to the participants to come? Like for the next round?
Yeah, sure. Yeah.
But I would save a lot of time. I don't know if it's tough for you because you'll have to also time their prep time and stuff. If it's tough
No,
for you,
I'll take care of that.
if you can do it, that'll be great. Or if you can ask another person, another student volunteer also do that, that'll be great.
No, I'll take care of it. Thank you. Yeah. So the time is up. I'll screen share the timer.
Okay then. So the next case that we have here, I'm just going to read it out. So we have the case facts of the case are SubG is an online multiplayer. 1 second, I'm so sorry. Oh. Yeah. So SubG is an online multiplayer game that is very similar to the game of PUBG played in the country of Atlantis. It is played widely by the young and old alike and has led to high levels of addiction among those who played, and many reports suggest that players of SubG start to display the aggressive behavior in real life. The government of Atlantis, concerned for the health and well-being of citizens, has banned the game without notifying the creators of SubG or asking offer any solution for this problem. Now, SubG has challenged this order in the Atlantis Supreme Court. Okay, and now we have Manan, who would be representing SubG, and Sai Samyukta would be representing the government of Atlantis. Manan, whenever you're ready.
I'm sorry to disturb. It's Sanyukta, not Samyukta.
Okay.
I'm sorry.
So sorry. Yeah.
Just give me like 5 seconds, right? Just 5 seconds. All right. Am I audible and visible?
Yes, you are.
All right,
Sanyuta,
so
you are also required to turn on video. Can I start the timer? Are you ready, Manan?
yeah, sure. 3, 2. Oh no, I'll just count myself down. Really sorry. 3, 2, 1, go. Panel, today in front of us we have a clear case of false accusations and I would say even defamation. Well, here let's just go through the facts of the case one by one. Firstly, it is clearly stated that people started being aggressive because of the game SubG, which was stated by a lot of reports, and that is why SubG got banned and banned by the government of Atlantis. Now, let's move on to the primary arguments of the plaintiff. Now, firstly, it was completely not true that the aggressive behavior of every single person was only because of playing SubG, because there are a lot of factors that contribute towards aggressive behavior, example, stress and whatnot. So just blaming it all on SubG is not the right thing to do. Secondly, considering hypothetically that SubG was responsible for the aggressive behavior in every single person that played it, well, the government was obligated to at least consult the company that there's something wrong with your company, and that is why you need to give us you need to improve in this spot or you just get banned. They never notified. They were obligated to do so. So it was completely it is completely the completely mistake of the government of Atlantis to not notify the people, like not notify the company. And thirdly, the addiction is under the control of the people itself. So we cannot consider the argument that the people were addicted and that is why SubG got banned, because it is again
concluding remarks.
Yeah, I'm just concluding. So again, it is all the people are themselves negligent enough, right? They didn't take care of themselves properly. So I believe that I made a clear-cut case and I rest my case.
Okay. Thank you so much, plaintiffs. Could all the other participants please mute yourselves? Yeah, okay. Cool. Next, we'll have the defendant.
Yeah, can I start?
Yeah.
Okay, so I would like to see timer. This one.
Yeah, please go ahead. I'm sure you'll take care of that.
Yeah. So I would like to begin by saying, according to many reports that we have received, all the players have high levels of addiction, and as the plaintiff said, addiction. Can I just take a second? Is that fine?
Oh yeah, I'm so sorry. Yeah, you
Yeah,
can.
I just want to restart. I'm sorry.
No problem. No problem.
Do you want to, should I reset to 90
Yeah,
seconds or?
Reset time.
Excuse me, could the organizer please notify Block and Tackle that I'll be joining late because I have a case going on right now?
Yeah, sure. I'll let them know.
Yeah, thank you very much.
Okay, yeah.
Just take a deep breath. It's just an event that cultures, online cultures. Okay? But yeah.
Okay, so I would like to start off by saying, from many reports that you've received, PUBG is a game that has to be stopped. It's similar to PUBG, which is battlefield game, and it many kids and adults play it. So it's a role model for kids, and they are the future of the country of Atlantis. So I don't think it is a very good example for the kids to play such a game like PUBG. And we have received many reports saying adults use it to plan schemes against the government, and that is why we have not noticed the creators about these. We have not offered. We are not offered solutions or notified the creators. It is a game that has to be stopped, and as the plaintiff said, games are played to relieve stress, but yeah, but then this is a game that not only relieves stress but also getting addicted to. Okay, okay, I'm just gonna stop here. I don't think I can do this. Yeah.
Just give your concluding remarks, generally. Sorry, take time.
Okay, I think the game should be stopped because it is not a good role model for anyone. It's not doing any good by staying in the market, and that is it.
Thank you so much. Now we'll be moving to the cross-questioning round. That is, defendant, you could ask 3 questions, up to 3 questions to the plaintiff, and then the plaintiff can ask up to 3 questions to the defendant. All right? So, Sai Sampte, you can ask up to 3 questions to the plaintiff whenever you're ready.
Just a second.
Take your time.
Okay, so you said games are played to relieve stress, right? So a game that has to be played has to be fun. Why do you? And this game of PUBG is a very aggressive game, I guess. So why do you say that playing this, relieves stress? It's not a game that relieves stress. And okay, yeah, I'll just conclude it there.
All right. Permission to answer the questions, panel? Yeah. Thank you. So firstly, answering to the question, like how exactly it is fun. Well, there are other games in the market too, like Call of Duty, Warzone, and whatnot. The Apex Legends also, they're like all violent games, and still people find it fun. So it is all based upon the popular opinion as to what exactly is fun and stress relieving. It is just that we go according to the trend. We make the games that people want. So we are not liable for that, first of all. And the aggression, again, I already stated, it's not only because of this one game. They play various other games, and just banning it completely is not the solution.
Okay, thank you. I am done.
Cool. Plaintiff, if you have any questions to the defendant.
Yeah, so I have 2 primary questions. Okay, so the first one is, so banning of PUBG doesn't make a lot of sense because, you know, after a ban of a particular game that was so damn popular, people are going to protest. And secondly, the economy is going to go down because, again, it was popular. We were generating a lot of revenue for you. So, so why did the government even take the step in the very first place?
Okay, first of all, for the government, the well-being is more important. I'm not going to say it's more important than the economy itself, but it's equally as important. And I'm sure we can recover from the fall, but the well-being comes first because kids are the future of the country.
Follow-up?
No follow-up, just ask another question.
All right. Okay, so secondly, the opposing counsel stated the people are planning schemes against the government. Doesn't that essentially imply that there's something wrong with the government and, you know, not necessarily PUBG, like PUBG as a whole? So like, what is the point of you banning PUBG when, you know, there's something wrong with the government? Just do something to your government, you know, like make some internal corrections in it.
Okay, this is a government, so there's of course going to be a lot of laws. I'm just saying they are planning schemes, not you know against. Okay, yeah, against the government, but it may not necessarily be destructive, you know. So yeah, it's just according to the reports that we've received.
Okay, yeah. Your last question.
Yeah, 1 second. All right, so yeah, I'm actually done. Yeah,
Okay, cool.
done. Yeah.
Thank you so much. Right. Varun, I hope that you have sent. Thank you so much. That is end of round 2. Now we have the other. Can you please tell the name of the next participants?
Yes, 1 second. So Tarun's teammate isn't here now, so I'll just put him up with another one. So Tarun and Tushar Jain can go.
Hey, excuse me. I thought it was me next, so because the
No,
list
I'm very sorry. We sent the case files to the wrong person. So we sent the same case files to Tarun and Tushar Jain. So I think Tushar received it late, so just give them 3 minutes. I'm really sorry about that delay.
Okay, wait. So who have you sent the case file to now?
So I sent it to 2 people. I forgot about Tarun. He has to leave. So I sent it the same case file to Tarun and Tushar Jain. So they will be going at now.
Okay.
Tarun and Tushar.
We're so sorry, Nandita. I'm so sorry, but like, yeah.
It's all right.
So Tarun and Tushar Jain will be going next.
Yes.
The thing is that if you share your screen also will be great for the participant because I have to take note of.
Yeah, sure.
Just one thing. We're going to be told right now who's prosecution, who's plaintiff, who's defendant, right?
Yeah.
I'm sorry to interrupt, but I can go next, right?
So we have Tarun and whom now?
Tushar Jain. Just give
Sindhi
them 2
model.
minutes.
So Chinmay Vidyalaya is Sindhi model.
Yeah.
Cool. Okay. Okay, cool.
I'm sorry for the confusion.
The case? No, it's all right. It's actually really hard to organize cultures online. I think our batch could never saw ourselves doing it because it's just so much more fun, just meeting people offline and stuff. But yeah, anyways, that just ruined the mood of this event. But have you sent them the case files?
Yes.
Okay.
Tushar, you've received the case file, right?
Tushar, please.
Sorry, I didn't hear you till now. What were you saying?
Could you turn on your
video? No, we sent you the case files. Did you?
Okay, 1 second, I will check. Can you just start my timer now? I couldn't see it.
Yeah, it's not a problem. I'll start.
I'm really sorry to repeat myself, but then I will be going next, right?
Varun, would she be going next?
Yes, you will. Do you have another event?
No. I was just asking since I started preparing for the topic you gave me.
No,
so-
we'll send you another
You
case file.
guys
For,
also
you'll
the
be going
other
next.
participants, you could just like mute the thing. You don't have to switch on your camera during prep time.
No, it was sent to me directly, so I just had without.
Yes, sir.
Yeah. Sorry. Thank you.
I'm saying the participants don't have to switch on their camera now. You could just like go to the other side of the room, prepare, and come back.
Oh, it's fine. But we haven't been told whether the prosecution or defense yet, so we'll be told that after this.
What?
We haven't been told whether.
Tushya will be for and Tarun will be against.
Yeah, I think that was made clear. So
yeah, I wasn't told that. I didn't hear.
That's why we had the Excel sheets, all right. So basically, I'm not going to read the case again, but okay, do I have to explain to each one of them?
No, you don't have to explain. You just have to tell me who's I'm the defendant, right?
Yeah, you would be
and
the
so
defendant.
I'm the government.
Tushar would be the plaintiff, yes.
Fine, okay.
I'll be speaking for the government, right?
Who's for Tushar? You would be speaking for the fisherman.
Okay.
You're the one suing the case.
Okay.
Suing the government. Okay, Varun, let's not do that then. You know what? Let's just like tell the case, give them 3 minutes. It's fine.
Okay.
Just a small doubt. Now, would it be reasonable to assume that the welfare project doesn't consist of just housing and has a little bit more stuff as well?
Yeah.
Thank you.
Tushar, time is up. Is it fine if we start?
Sorry?
Your time is up. Is it fine if we start now?
Okay, yeah.
Yeah, okay.
Yeah, so I'll start.
Just wait 1 second. Okay.
We have 2 volunteers for this event, right? I think there was another person called
Yes.
Sai Samyukta.
Yes.
Yeah.
Okay. Sai, if you could do this, what you could do is at the time of cross questioning, select 2 participants who are supposed to go next, inform them, send in the case file. All right.
Sure. Okay.
Okay. And all the participants, I think I don't have to explain to each one of them who is the plaintiff, who is the defendant. I'm going to repeat this one more time. If you're the person filing the suit in the court, you are the plaintiff. That is, in simple terms, for the case, and the other person who's against the case is actually defending the suit, and they'll be against the case. Okay, this is the most simple terms I think I can explain this. But yes, so now the case. So the government of Wakanda has decided to beautify all the beaches in the country in order to promote them as tourist destination and boost the economy. It seeks to subsequently develop a welfare project for the fishermen who live along the coastline, move them to housing boards which have better facilities for living as well. Now, the reallocation would, however, put the fishermen 8 to 15 kilometers away from the coast, and this is where the housing boards are located. The fishermen dragged the government to court over the matter, terming relocation as unfair and unreasonable. Without just saying that all the case files in this case are actually inspired from real life events, and it would be great if you knew that where this has been taken from. But yeah, cool. I'm just saying it just adds substance to your case because all these have been done in real life. Cool. Okay. So we have who's for the case?
Tushar is for the case.
Tushar, you're for the case?
Yeah.
So
and
you
Tarun will be against.
Okay. And Tushar, you'd be speaking for the fishermen. Tarun would be representing the government, right? Cool. Yeah, whenever you're ready. Please switch on your camera while you speak. That's it.
I'll start. Okay.
I'm unable to see you, Tushar. Are you there?
It says Tushya J. Can you see?
Yeah, his camera is on. I'm able to see him as well.
1
I
second.
can see myself.
Yeah. Cool. I can.
Actually, I have logged into another device for the audio.
Yeah, that's a thing. I have seen that. Cool. Please go ahead.
Okay, start the timer when you're ready. Sure.
Okay. Good evening, Judge. I am here to represent the plight of the fishermen who have been relocated due to the welfare project of the government. The government has the government has created a new beautification project along the coastline to promote tourism, which I believe is extremely unfair for the fishermen. The government has proposed to relocate the fishermen about 8 to 15 kilometers away from the coastline. However, this is extremely unfair for the fishermen because their livelihood directly depends on the coastline. If they would be relocated about 15 kilometers away from the coastline, they would never be able to come every morning for catching fish, which is their main livelihood opportunity. It is like losing bread for them. So I would like to lay emphasis on the fact if whether beautification for the country is more important than the welfare of the people itself. You cannot just prefer one sect of people over the other. By building a beautification project along the coastline and removing the fishermen from there, you would just be encouraging foreign tourists to come to India, and this would just add some little revenue to the economy. Whereas the fishermen constitute about 10% of the entire Indian economy, and this would be a great loss for the country. And the country giving more importance to foreign people instead of its own fishermen is really unfair. So I believe that the project should be cancelled and the fishermen should be allowed to live where they are. Thank you.
Thank you so much, Plaintiff. Now we'll be moving to the defendant.
Thank you, Your Honor. May I begin?
Yeah.
Good evening, Your Honor. I am here today to represent the government on this case. And firstly, I would like to open by saying that this welfare project is in fact completely reasonable, as not only does it lead to greater economic opportunities for the country of Wakanda through the beaches and the tourism program, but also it leads to a better living conditions for fishermen. Because not only does the welfare project offer housing, we also offer several other amenities such as forms of personal transportation. Since Wakanda is a country with an extremely high GDP due to our dependence on the commodity of vibranium, we are in fact able to offer such amenities. And then secondly, not only is this reasonable for the fishermen, and also would it lead to more economic growth for the country, contrary to what the opposing counsel said, we do actually need to spend money on tourism, because as we know, tourism is in fact a growing industry in Wakanda, and although it may not be huge today, it does in fact have the potential to produce the country billions and billions of dollars increase the country's GDP by billions and billions of dollars in the future. With that, I would like to conclude by saying that this in fact is a very reasonable welfare settlement, and I would like to rest my case. Thank you.
Thank you so much, defendant. Now you could ask 3 questions to the plaintiff, followed by 3 questions by the plaintiff.
Thank you, Your Honor. Opposing counsel, my first question to you would be, since you do not consider this welfare package to be reasonable, what would be a welfare package that you might consider to be reasonable?
I believe that none of the projects by government to beautify the coastline could in fact help the fishermen, because the fishermen directly depend on their proximity to the coastline to be able to earn their livelihood. So if you create any project along the coastline, it will surely displace the fishermen, and rehabilitating them will take a lot of time, and they won't be able to survive that long without their livelihood opportunities.
Judge, Your Honor, may I ask the second question?
Yeah.
Thank you.
Yeah.
Opposing counsel, in your opening statement, you specifically stated that the government giving more importance to foreign people is something that they shouldn't do. Now, I would like to hear why exactly does this argument take place? Because this is in fact an argument about tourism, not concerning immigration of sorts. So why exactly does the opposing counsel believe so?
Like by foreign people, I was referring to foreign tourists. When you will be doing the beautification of the beaches, it is to attract tourists, right? So on a major portion, it will attract foreign tourists because that's what the project suggests. So you are doing all the beautification project for attracting foreign tourists, but you are displacing your own fishermen in the process. So just for encouraging tourism in just a small area, you cannot displace a great part of the population.
Your Honor, may I ask my last question? Thank you, Your Honor. Thank you, opposing counsel. To conclude, I would like to ask you one question. So simple yes or no would suffice. So you say that no matter what solution we give, what welfare policy we introduce, or whatever form of personal transport we give to the fishermen who we are housing elsewhere, you say that it will never be enough. No matter what solution we provide, won't be enough. Simple yes or
no. No, I want you to consider, if you're giving better transportation, how will it help the fishermen? Just transportation wouldn't help them, right? It wouldn't give them 2 square meals every day. Transportation is otherwise of no use to them unless they have all the basic needs available to them. So by welfare projects, you cannot displace them from their original location. You have to introduce such projects that give them better access to all facilities rather than displacing them from their home location.
Okay. Thank you so much. Plaintiff, your 3 questions.
Yeah. So my first question is, should I ask him?
Just give him a minute. Give him a minute. Take a minute. It's all right. It's all right.
Okay, then can I just give me 30 seconds?
Yeah.
Yeah.
Okay.
Yes. Okay. Apologies for that.
No problem. All of us are at home. But yeah. Cool. Yeah. So Plaintiff, whenever you're ready.
Yeah. So my first question to the government, to the government would be, how would implementing the welfare, like the beautification project, benefit the fishermen in any way? You said that you will be giving better transportation and all other facilities, but how would it help them directly? Transportation isn't anything that can give them a better standard of living. Transportation is of no use to them. So how will your rehabilitation project give them better facilities and all the basic needs, that is 2 square meals every day, good clothing, shelter and all?
Your Honor, may I answer? Thank you, Your Honor. Now, considering that these fishermen are being relocated by 8 to 15 kilometers itself, with their livelihood is at risk, we can assume that they do live in economically poorer conditions. And for someone living in economically poorer conditions, better housing, better living conditions, and other facilities such as water and power do in fact make a significant difference. And that does in fact help them put 2 square meals on the get to 3 square meals a day. The reason being, they do not have they live in government housing with subsidized water and electricity, so they do not have to spend as much money on utilities as they normally do.
Can I ask a follow-up, or I have to go with the next question?
Next question.
Okay. Yeah. So the main point over here is all the fishermen are, of course, uneducated. That's why they took the fishing occupation. So by relocating them to a better place, having electricity, having power will in no way help them when they are not able to earn money itself. They need money to be able to get food. Like by being fishermen, they are able to catch their own food from the sea and make their living.
Question, please.
Yeah. So relocating them will not help them in any way. So why are you so specific about favoring other people over the fishermen?
I believe that question, we disagree with the basis of the question that.
Okay, I'm just going to rephrase the question because
sure.
He's saying, considering all the disadvantages posed to the fisherman community, why does the government still propose this scheme? That's it.
Sure, Your Honor. May I answer now?
Yeah, please go ahead.
Thank you. Yes, we do in fact see that the fisherman community does face a fair bit of disadvantages, but we do firmly believe that the welfare scheme we are offering with better housing, better transport to get them to the coast and back, does in fact help them quite a bit. And we believe that the overall benefits that the welfare scheme offers outweigh the disadvantage.
Okay, cool. Thank you so much. So that concludes this round 3. We will let you know of the results once we tell the finals. Okay, Sai, Samyukta, have you told the next participants who the case files? Have you sent it to them?
Yes, I've sent it to them.
Okay.
So they can start.
Could you just send it on the Zoom chat, please?
Sure, I'll send it to everyone.
Right. Perfect. Okay. Who are the next participants for and against? Is your prep time over? Did you time them?
It's over.
Okay. Could the participants please switch on your cameras?
Sanya is going for the topic and Nandita is for against.
Sanya from which school?
Kola Saraswati.
Kola Saraswati Vaishnav Senior Secondary School. And Nandita is from NPS International School, Mysore.
Cool. Okay, I'm just going to read out the case, but yeah. So Mr. and Mrs. Smith buy a house that is situated near a cricket ground. Children have been playing cricket for every evening for about 50 years now. When the ball does come into the compound, the ball has also broken their windows twice. Mr. and Mrs. Smith sue the people who play, requesting the court to order them to stop playing cricket as a nuisance. Two things to note is that the house is a legal structure that has all required permissions, and the cricket ground is the last patch of open land available in the radius of about 5 kilometers. So these are the facts of the case. I think the facts of the case. Sanya, you would be representing Mr. and Mrs. Smith, and Nanta would be representing the children. Yeah. Okay, Sanya, whenever you're ready.
Audible?
Right now you are. Yeah.
Okay, just give me a minute, please. Okay, can I start?
Just give me 1 minute. I'm so sorry. Hi, yeah. Please go ahead.
I'm starting. Can I? Okay. Greetings to the panel. So I'll be representing Mr. and Mrs. Smith to sue the boys who are playing cricket on that ground. The case today is the boys that play cricket on the ground have been invading, trespassing Mr. and Mrs. Smith's house. That is, the ball comes invading into the compound and also has broken windows twice, which is again a personal expense for the family, for the couple. Also, I would like to request the court to stop this nuisance, since to bring to the notice that the house is a legal structure that has been there for around 50 years since the ground, and has all required permissions. And the cricket ground is just an open patch which is available in a radius of 5 kilometers. The boys are requested to find another open ground and play cricket there, as it is disturbing the couple and their livelihood. Also, this would also request the boys to kindly pay them the amount or the personal expense that Mr. and Mrs. Smith have been undergoing since they've broken windows. And by this stating that, I would like to rest my case. Panel, you're muted.
Thank you so much. Next would be the defendant.
Yeah. Good morning. So This is a quintessential example of a case between the tension between a community and individual. So first of all, the judgment should be in favor of the community or of the public, and it should prevail over the private interests. Now, why? Public interest of everyone is superior to a private interest of an individual. And this open patch of ground has been there for 50 years, and the children have been playing there for over 50 years. Now, in the facts, we see that the couple buy their house. So they knew that this open patch of ground was there. So they technically even bought the house for their benefit as well. And they knew those restrictions that would come along with buying the house in that area. And private interests are always subject public interest, and it isn't fair that or it cannot be justified that public interest is less than less than private interest. So they bought the house near the cricket ground for their benefit, and I'd like to conclude by saying that the court should make the judgment in favor of the boys or the children, because they knew the facts. Thank you.
Thank you so much. Now, defendant, you can ask up to 3 questions to the plaintiff. Yeah.
Yes. Okay. So the plaintiff mentions that how is it's not it was orally foreseeable for days that they would buy a house near the ground. So why do you say that it's justifiable for them? You also mentioned that they've been staying there for 50 years and it's not in case. So I'd just like to pinpoint that. And then why do you think their interest? Why do you think their interest should prevail over the public interest of many people living in that area?
What are the public
I'm unable to hear you, plaintiff.
Am I audible now?
Yeah.
Okay, so can I answer the question?
Yeah.
Okay, it's an open patch of land which has no government permission or anything. And secondly, the structure has been there. Also, it is not mentioned that they've been living there. I mentioned that there was a structure in the same open patch of ground, and Mr. and Mrs. Smith have bought the house now. Since now it is a habitant, the boys are requested to stop playing since it is affecting the property of the couple.
Your next question, defendant.
Yes. So there's public policies stating that public okay, fine, you do mention that so there's public policies mentioning that public interest should be, and you say that all right, so there are children residing in that area and there's no other ground for another in the radius of 5 kilometers. So there are other people residing there. So it's not only children that use the open patch of ground. So what makes you justify that they've only bought the house now? So what makes you justify that they cannot stop the everyday activity of these children playing there every day, right? So how do you justify that? They've been practicing it for over 50 years. So how do you justify it? Yeah.
That structure has been there on the same patch of land. The structure was an abandoned house with no habitants. That's why there was no problem for the people playing there. But now that the couple has bought the house, it is a habitant of 2 people living there, which is again invading the property because of the nuisance that the boys are creating on the ground. It might be an everyday activity, but now that there are people living, it is disturbing the residing people around. So it is requested that the boys stop.
Plaintiff, I'm going to stop you right there. I think it's too much of an interpretation from the plaintiff's side to think the house is in an abandoned structure. So I'm going to give you a few 10 seconds to rephrase that answer. Okay. Because to interpret that this house has been abandoned, now only someone's buying that is a bit erroneous on your side and won't let argument to continue. Okay. They just buy a house that's already been situated near a cricket ground. There's no reason or why it has been abandoned before, now only there are people living in it. Okay. Just take a few 10 seconds and answer that question again. Okay, cool.
Yeah.
Plaintiff?
I have sorry. Continue. I'm so sorry.
The point that I can't use the abandoned structure point. Okay, the property has been situated near the cricket ground, but now it is causing problem to Mr. and Mrs. Smith because they are having personal expenses because of the broken windows. That is because of the ball that comes invading in the property while the boys are playing cricket.
Okay. So what alternatives do you suggest for the children living in the radius of 5 kilometers, since there's no other open patch of ground? What other alternative do you suggest for in favor of the public interest?
Can I go forward, panel? Am I audible?
No, you are. Yeah.
Okay. So I would request the boys to, okay, the cricket is not only activity, there are many other activities. So they can go over for, as an alternatives, they can go over for some other kind of sports that they can play on an open ground instead of cricket, because that is causing a problem to the family. Cool. That can be an alternative.
Yeah. Plaintiff, your questions?
Just give me 1 minute, please. Can I pose my first question?
Yes.
Okay. 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 So my first question is that since the boys now knew that there's a couple living in the house, well, they should have been careful while playing cricket because it was entering into the property. So what do you think should have been the first step of the people playing cricket to not disturb the residents living around?
I'm sorry, can you just repeat
Could
yourself?
you state the question again? Even I didn't get your question.
My question is, now that the boys know that the couple are living in the house, my question is that what steps should the boys have taken so that it would not disturb the people living around, the residents living around, because of cricket?
All right. So cricket is a sport where you can't just control yourself and play. And I think they're not mature. They might not be, since they mentioned children. I don't think they're mature enough to sort of control how they can bat every single time. So I don't believe they should have taken precautions because they've been playing there for over 50 years and they've just hit the window twice, I believe, and that must have been by accident. Yeah.
That's all, panel. That was the only question.
Okay, fine. I have one question to ask to the defendant and the plaintiff. Firstly, the defendant. Defendant, considering that nuisance itself is very subjective, right? Regardless of public interest, regardless of private interest, if a citizen's right is going to get affected, don't you think that you don't think as the government it would be to meditate their interests more? Considering this is just a patch of open land and not a park per se.
Oh, so as I said in my argument, I think, again, public interest holds more of a value than private interest, or a community versus individual. Community should prevail because, yeah, as I said, public interest is more superior.
Okay, cool. To the plaintiff, just one question. Can you hear me?
Yes, panel, please. Hello.
Yeah. Okay. So you're representing Mr. and Mrs. Smith, right? Considering that Mrs. and Mrs. Smith already knew that this house has been placed near a critical ground, wouldn't have been come with such reasonable foreseeability that this might happen when they purchase the property.
Okay. This might have happened while purchasing the property, but the invasion have been quite severe. There have been 2 times, and they're causing a personal loss to the couple. So they had.
Could you please restate your answer?
My answer to this question will be that the couple knew that the cricket ground and people are playing cricket there from the last 50 years, but they had no idea that there would be so much of disturbance from the boys, so they had taken up the property there.
Okay, cool. Thank you so much. Thank you so much, participants. We'll be moving on to the next round. Have the next participants been notified of their participation? Okay.
Yeah, we have been notified.
Okay. I hope your preparations time is also over.
Yeah.
Yeah.
All right. Okay. Could you please, Varun or Sai, could you please let me know who's plaintiff, who is the defendant?
Harshavardhan will be for, and Sai Vaishnavi will be for against the topic.
Harshavardhan, which school?
Saraswati Vidyalaya.
Okay. And who will be the defendant?
Sai Vaishnavi.
I am the defendant.
Excuse me, I'm very sorry to interrupt. Who is the next participant? Can I please know? Like, what is the who is the next participant, please?
Next will be Meghna and Karan.
Okay, fine. It is the 6th one, right?
Yes. Yeah, next will be the 6th.
Okay, thank you. Thank you. Sorry for interrupting.
No problem. Yeah, okay. I'm just going to repeat the case. Captain Bose is an experienced pilot with Malaysian Airlines. On a routine flight which had 250 passengers on board, birds strike the plane while it was taking off. This led the engines to fail at a low altitude where the plane was at the risk of crashing into many skyscrapers of the city. Captain Bose spotted the Thames River as the safest possible option of landing safely. Unfortunately, Mr. Gump died in the process. Investigations by the Transportation Safety Board revealed that there was a 75% chance of landing safely at the airport itself. After the report was out, the family of Mr. Gump sues Captain Bose. Just one correction in that. Sues Captain Bose.
Yeah.
Okay. So now, Harshavardhan, you would be representing the Gump family,
yes.
And Sai Vaishnavi, you'll be representing Captain Bose. All right. Cool. So Harshavardhan, whenever you're ready, please.
Yeah, I'm ready now. Good morning, Your Honor. I am representing the Gump family in this incident. So I would like to start my case with 5 points. First point: airlines is a dangerous, risky jobs which requires a lot of alertness, and they have to pay attention at all times. So they have to check. That's why air hostesses are paid. They have to make sure that everything is safe during the flight, and they are at every time when they first start, they make sure that everyone has to put their seat belt and all. So that is my first point. Second point, the bird, it is clearly given, but while taking off itself, the bird was identified. So the captain Bose was an experienced pilot. So what must have he done? He must have stopped the flight and make sure to postpone it. But that was not what he had done. So his experience, even though he was experienced, he took the wrong decision, Your Honor. That's my second point. Third point. See, it is clearly given that many skyscrapers were about to be crashed because of Mr. Bose's wrong decision. So not only Mr. Gump's life was gone, but many billions of people's life could also been gone. That is my third point. Fourth point, 75% of chance were there to come and land at the airport itself. So instead of taking that, was a very wrong decision, Your Honor, and the life was lost. Fifth point, any sum of money cannot be given to compensate as a life, to give a life. So the Gump family are very sad, and they require severe action, Your Honor. I hope you will do the same. Thank you, Your Honor.
Thank you so much, plaintiff. Next, we'll be moving to the defendant.
Good morning, Your Honor. I am here to represent on behalf of Captain Bose. So Captain Bose is very experienced pilot, right?
he has been traveling from various countries to countries, and he has been taking the passengers very safely from country to country. And Captain Bose was really unaware of the statement that the engine was actually failed due to the birds. See, birds are like they are flying in the sky, right? So aeroplane also do fly in the sky to travel from one country to country. See, that is not the fault of Captain Bose. So Captain Bose is the only the pilot who will take the passengers to country. See, Captain Bose is not involved in the Gum's death. So see, Gum's death can be due to also he also can be died due to some heart problem also. So Captain Bose took a very good step from not getting crashed to the skyscraper, and he has taken to the Thames River where it is 75%. At that situation, it is very difficult for the pilot to take a correct decision, and it has to save all the lives of the passengers, right? So like Gum's family, he might be an old man, or he might have any heart problem or anything else, but he like every passengers are safe. They are all healthy and hale and healthy. But Gum may also have died after landing onto the airport. That doesn't mean that Captain Bose is responsible for the death of the Gums, right? So that is what I will also tell. See, Captain Bose is very experienced. He took all the passengers from one country to other very safely, and there is no involvement of Captain Bose in the Gum's death. So I will conclude the statement that there is no involvement of Captain Bose, that is my client, in this.
Thank you so much. Okay. Now, defendant, you can ask up to 3 questions to the plaintiff, and plaintiff can ask 3 questions to the defendant whenever you're ready.
So may I, Your Honor?
Yeah.
So I would ask the lawyer of the Gum's family. So why the Gum did have any health problem or health issue during the travel of the travel during the
Clearly, it is not given that he has any medical conditions, and no, he was hale and healthy. So, you are selling that Gump only and died. Others are healthy. So, you have to take responsibility for the death of my client because of your because of the carelessness of your very experienced pilot. See, he is a very experienced man and who routinely goes to one place from one country to another. So, if he has experience, and clearly it is given that while taking off itself, the bird was crashed. So, why must have he was taken off? That is my first point. If he has not taken off, Gump would have not died, a life saved. And even if have taken out, and 75% chance was there to come and land at the airport. Why didn't he do that? That's my second thing. So if we had done any one thing properly, a life would have been saved.
Yeah.
So that's my answer, Your Honor.
Thank you, plaintiff, but you can't respond a question to a question. Okay, I love the rhetoric that you're going in, but you can't do that. It's not feasible. I mean, usually if there's a court and everyone's watching, it'd be great to witness, but not for this lawyer of event. Okay, but yeah, your next question.
See, as it is given by the plaintiff that the air hostess are really responsible for the seatbelt, then why are you suing the Captain Bose? Captain Bose is a pilot who takes the passengers from one place to other, right? So why are you suing Captain Bose in this? Why are you not suing the air hostess, right?
Okay, can I answer now? See, air hostess are there to help when something is happening. The fault is not mainly on the air hostess, but mainly on the captain, because it was his decision to take the flight. So my first point must be suing him, because he is the one who is responsible for the death. Air hostess could have stopped it or might not be stopping it, but it was not in their hands. But the main reason was why Captain Bose took off the flight and did not land it properly. That's my point, Your Honor.
Okay.
So, Your Honor, I'm finished with the questions.
Okay, thank you so much, Defendant.
Can I go with the questions, Your Honor?
Yeah.
So, okay, my first question is, why did Captain Rogers, who is Captain Bose, who was an experienced pilot, one who routinely goes, why did he take off the plane? He clearly knew that a bird had attacked, and this is very common in air flights, Your Honor. If a bird comes, the windscreen will be blocked, so they must either take some precautionary steps, and they didn't. Okay, why did the Captain Rogers take off the flight when he knew this would happen?
Captain Bose is unaware that the engine has failed. See, birds are common things which come during the flight, right? So it is not the one that bird hit and bird comes in the front of the, like it is a window of the airplane. That doesn't matter that it is going to there is going to be a fault in the engine, right? So there is no fault in coming a bird in front of the airplane, right? It is the fault in the engine, not in the bird.
Okay, my next question, Your Honor. Having been trained for life and death situations is a pilot's job, Your Honor, and clearly it states that 75% chance was there to come and land at the airport. Why didn't he do it? That's my question, Your Honor.
See, in that situation, the captain boss is very experienced. Everyone knows that. But in that situation, it's a very dangerous situation, which he has to take like he has to take everything in on his hands, and he has to save the life of the passengers. So at that time, the best option is he has to land in the Thames River, right? So that is the one I could also tell that my client has taken the best decision to save the life of the passengers. That is what. Yes, take it.
Okay, I'm done with the question.
Okay, thank you so much. Thank you so much. Sai, I hope you inform the next participants.
Yes, I've messaged them. Yeah.
Tell them.
I'll post it. Yes, the time's up actually.
Okay. Yes, it's actually a wonderful film. You guys should watch whenever you're free. This it actually happened in real life. Actually, I think it was in the 1980s, where the captain.
Hudson River.
What? I'm sorry. Who was that? Yeah, but anyways, that was a real life incident that happened in Washington D.C. in 1980s. It was actually a very controversial court case in the Supreme Court of Washington. But yes, now moving on to the next case. Who are the next two participants?
It will be Harshavardhan and Meghna.
Harshavardhan.
I think I just finished.
Sorry. It will be
Karan and Meghna.
Karan and Meghna. Sorry. Karan.
Right. Okay. So Karan is for, I'm assuming, and Meghna is against.
I'm against, and Meghna is for.
Okay. Meghna's which school?
Babaji Vidyash.
Okay, and Karan?
DV Boys Gopalpuram.
Okay, fine. I'm just going to read out the cases again for all the people who are seeing this. A, B, C, and D, E are companies that offer telecom services with the goal of driving E out of business. A, B, C, D come together to form a joint venture called Maro. Maro offers calling for free and data at throwaway prices, and within a few months, most of the consumers in a telecom market have switched to Maro. This causes a lot of financial problems to E as it had lost over 90% of its consumers to Maro and was at the risk of shutting down. Now, E sues Maro, that is the whole entire joint venture, for being anti-competitive and for coming together only with the intent of causing it to shut down. Now we have Meghna who would be representing E and Karan who would be representing Maro, that is the joint venture of A, B, C, and D. Okay, Meghna.
Sorry to interrupt. Tarun, you're requested to join Pinayan event right now.
Oh, geez. Okay, fine. I'll just do that right now. Thank you so much.
Sorry, you can continue.
Yeah, cool. So yeah, Plaintiff, Meghna, whenever you're ready, you'd be representing E.
I'm going to be.
I'm sorry?
I'm going to be.
Oh, aren't you for? Are you for?
I'm for. I'm representing E and Karan is representing Maro.
Sorry, but the case is against.
Wait, who's for and who's against?
Against.
I'm for.
Okay, if Meghna is for, that means she is.
Meghna is for and Karan is against.
Okay.
Yeah.
Meghna is for, she would be E because she's filing the suit. She will be the plaintiff.
Okay.
And because you're again, you'll be defending the case. Then you will be Mara. All right? Okay. So Meghna, whenever you're ready.
I'm ready. May I start?
Yeah.
I'm here today to represent company E, and we're suing against Maro, which is a joint venture of A, B, C, and D. And the problem here is that the reason they've come together is purely to put E out of business. And that is completely unjust to us, to E, because it doesn't give us a fighting chance. 4 companies versus 1 is not a fair fight. And it's also proven that the only reason they're coming together, it's not for their benefit, it's not for the benefit of their consumers, it's not for the customers, it's purely for their benefit to kick out a competitor. And that doesn't seem fair to me. And they also say that Maro offers calling for free and data throwaway. They never used to do this before, only when they decided to come together as a joint venture and to push company E out of the market. They decided to offer this feature, and that's not allowed. This has caused a lot of problems to company E. They've lost over 90% of the consumers, and they've all moved to Maro. And it's not fair for this company because E has a lot of value to add to the market. But then if they're being shut down just because all the other companies decide to make one as the scapegoat, that's not fair to them. Is it okay if I stop now?
Yeah, sure. Cool. Thank you so much. Thank you so much, Plaintiff. We'll be moving to the defendant whenever you're ready.
I'm ready.
Cool, go ahead.
So the sole reason of the four companies coming together was to provide better services to the people at lower rates. We had we didn't want you to go out of business or anything. We just wanted to provide good services to the people at lower rates. We just wanted to do betterment for the society, and there was no grouping over here. We want people to be able to do calls and have data for very low prices, which is the sole reason. And there was like no intention to get you out of business. That was just us providing better services and you not being able to match up to our prices. We four companies as a whole who created Maro didn't feel that we had to add you into our thing because we felt providing better services didn't require another company and four of us could do it together. And I don't think you have any proof to prove your point that we had done it for the sole reason of getting you out of business. There was no blood against you. It was just for the sole purpose of getting good customers, providing them good services, as well as creating profit for our company. Yeah, I would like to stop as well.
Okay. Defendant, whenever you're ready, you can ask your 3 questions to the plaintiff.
Yeah. Should I go with my first question?
Yeah.
I would like to ask, why do you think it was done to run you out of business?
Well, we have a case that says, with the goal of driving E out of business, A, B, C, and D come together to form a joint venture called Maro. So what I find here is, right now we were growing. Company E was growing in its profits. That's when companies A, B, C, and D decided to form Maro to run us out of business. That's why I stated that.
I mean, that's okay.
Okay. Your next question.
In business, people always look for making greater profits, and we really don't think about companies. We don't really think about how other companies would lose customers or gain customers. We just want to make profit for ourselves.
Question.
So what makes you think that you putting the case against us is how is it even?
I'm not sure I get your question. Could you just take a few seconds to rephrase?
Yeah.
Yeah.
I mean, companies we as a company are just here looking to make profits. I don't understand why it would be a problem for you, because like people come together in order to make greater profits. So I don't think there's a case over here, because our sole reason is to make profits and provide better services to people. So I don't think the case stands. I just want to know why you think that it's a fair case for you to put up against us.
I'm not sure I get the question. What are you asking me?
My question is like, why do you think?
Okay, I'm going to rephrase it. It's common parlance in business operations to maximize your profits. So, in their opinion, in this outlook, it's justified to do so. Why do you think they're against? That's basically it.
Okay. Let's see. These companies came together recently, and when they came together, they offered calling for free and data throwaway. This is something that they've never been doing before. And our company feels that they started doing this only because they wanted to send company E out of business. and not purely for their benefit, because that's what our reports have been telling us.
Cool. Okay. Do you have any other question, defendant?
No, I'm done.
Cool. Plaintiff, your questions?
Can I have a minute?
Yeah, sure.
Okay. My first question would be that when you guys, when the 4 companies came together, was it part of the plan to give calling for free and data at Ruby? Because that was probably the reason why you came together, to send us out of business. So my question is, what was the intention behind coming together?
The sole intention for us to come together was to provide better services to people at lower rates. I mean, that was the whole 1 minute of my speech.
Okay, cool. Thank you.
No other questions, Your Honor.
Okay. I have one question to the plaintiff and the defendant. Firstly, the defendant, don't you think it's quite coincidental when A, B, and C, and D are competitive players in the same market to come up with a joint venture that coincidentally makes E suffer?
In business, there are people who are going to come together in order to make greater profits. People going out of business is an outcome because we are able to provide better services that they aren't able to match. Customers do come to people who can provide better services, which we have successfully been able to do, while the other people in the market haven't been able to match. I mean, it is a part and parcel of business, and it is what happens.
All right. Okay. And to the plaintiff, considering people usually say all is fair in love and war, and even in business, why do you think there's more of an intention, malicious intent towards E alone, but not as a profit maximization objective of these companies?
There are 5 major companies that offer telecom services, and I found it not fair that 4 of them group against one, because that offers an absolute disadvantage to the one company that's not in the joint venture, because it's 4 strong companies against another one small company, so it's clearly overpowering.
Okay, cool. Yeah, thank you so much. Oh, wait, are you guys 12th standard or 11th standard? Which grade are you both in?
12th.
11th.
Both of you are 12th?
I'm in 12th, she's in 11th.
Oh, okay, cool. No, you learn it in economics in 12th standard. Basically, that's the thing. About Lawyer Rep, it's always this intellectual event in cultural scenes. Basically, this whole thing's called monopolistic competition. But basically what Geo did, right?
Yeah.
Geo literally tried to, but they didn't, it wasn't a joint venture per se, but Geo literally put the other telecom players out of the market and stuff. But that was a case filed in the Supreme Court as well in India. Anyways, yeah, so it's always good to gain general knowledge while you're reasoning it out in these culture events. But yeah, anyway, so we thank you so much. We'll be going on to the next. Would this be the last one, Varun?
Sorry?
Would this be the last one of the prelims?
No, we
have 5 or 6 more to go. 5 or 6 more to go.
Okay, cool. Yeah, okay. Have you notified the next participants?
Yes.
Okay, cool. Could you just tell me the names for and against?
It will be Surati Sundari, who's going to go for
which school?
GRT Mahalakshmi, and it will be Rajat, who's from National Academy for Learning, who will be going.
I'm sorry, the name?
It's Rajat S.
Rajat.
Shruti Sundari. It's Shruti Sundari.
Yeah. The defendant?
It will be Rajat, who's going against National Academy.
Please turn on your videos. Shruti and Rajat. Rajat, okay. Right. Okay, fine. Yeah. So, have both of them switched on the videos?
Excuse me.
I'm unable to hear you or see you. Plaintiff. Varun and are you able to
I'm sorry
see?
for the interruption. I'm sorry. Am I audible and visible?
Yeah. Yes, you are.
Thank you.
Cool. Okay. So I'm just going to say the case again to the audience here. So a girl named Isha purchases a skin betterment or skin whitening cream called White and Narcy, which is similar to the product Fair and Lovely. On the back of the product, a recommended amount of usage in a day, the recommended amount of usage is mentioned. But Isha uses more than the recommended amount with the intent of making her skin fair. However, she gets a severe skin disease as a result of this, which majorly impacts her appearance. She sues the company for this. So, Kansing Shruti would be the plaintiff, you'd be representing Isha, and Rajni would be representing White and Narcy, the company White and Narcy. So, could you please share your screen with for the timer, Varun?
Yeah.
Right, okay. Whenever you're ready, Plaintiff.
May I begin, Your Honor?
Yeah. Please don't call me. Yeah, whenever you're ready.
Morning greetings to you, Keshav. I am representing the case of Isha versus White and Nasi, and I am appearing for the plaintiff, Isha, who is my client. So the case goes on. Isha purchasing the skin betterment cream, which is provided by White and Nasi, and it is very much similar to the product Fair and Lovely. And she has been using the product for a month, and she, as a result, she has lost her total appearance, and she has a severe skin disease. And she consults the doctor for this, and the doctor has presented a report that this was because of the cream provided by Fair and Lovely. It was also found that Isha has used more than the limit that has been given, but doctor says that clearly that this was not only because of the unlimited usage, but it is also because of the mixtures that were used in the cream. It was exceeding the limit. It was the mixtures used in the cream was exceeding the limit, and Isha has now totally lost her appearance. Now Isha, my client, is claiming for a compensation from the White and Nasi company for the compensation for her medical treatments and for her lost appearance. I also have the evidence of the doctor report where it is clearly stated that White and Nasi have not have exceeded the limit of the mixtures provided in the cream. I think it's enough. That's it, Your Honor. Thank you.
Okay. Thank you, plaintiff. We'll be moving to the defendant.
Okay. Good morning, ladies and gentlemen. Guidelines make our lives. Boundaries, limitations mold our lives in ways we cannot begin to comprehend fully. My client, the defendant, has been sued by the plaintiff on the grounds that she used the product more than recommended, even after having the knowledge of what the limitations of using the product, White and Nasi, are. We, my defendant in particular, are in no way responsible for the actions of the girl who is suffering from a skin disease. Re-emphasizing, it was the girl's choice to use the product more than recommended, and the consequences of her own actions are here today in front of you. As I address the panel now, I want to mention that we serve millions of customers all around the world. But is it a coincidence that we only see one customer here suing us? I don't think so. All I want to say is our product had its limitations on the pack itself. She didn't have to do any further research at all. And it was right in front of her of what to use, how much to use, and how much not to use. I am Albert.
All right. Okay, cool. Defendant, whenever you're ready, your questions to the plaintiffs.
Right. Okay. My first question is gonna be: wasn't your client aware of the limitations that were posed on the product itself, on the package of the product itself?
May I answer, Your Honor?
Yeah.
So, your question, thank you for the question. First of all, she was aware of the limitations that was provided behind the product. And she was adversely, attracted towards the product because of the major advertisements and huge kind of booms given for this product. And now, what I'm stating is, she has used only a little amount beyond the usage, and it is clear that she didn't lose her appearance only because of the exceeded use of the product. It is clearly found, and I've also shown evidence for that.
Okay, my next question is gonna be, it's mentioned that the usage of the product was more than the recommended on a daily basis, right? So so we can assume that she used more than recommended over a long period of time. Can you tell me what the cause of her actions was?
No. She didn't. She did not use it for more on a daily basis. She only used it more on weekly basis, and she used it for a month. And our cause of action was her attraction towards the product. And as you said in your opening statement, that many of the customers, you have millions of customers, and many of them have been using this, and she has been recommended by many of the customers. And she has once also called the customer care for this product to know about more details, because of the she has been getting more symptoms by using this product. Even then, the answer given by them was, no, you can use this on daily basis, it would be fine. So that's why she used
That'll
it.
be all. Thank you so much. Your last question, Defendant? Oh yeah, you completed?
2 questions is fine.
Okay, cool. Plaintiff, your questions?
Yes, sure. So my first question will be, do you think the only reason for her lost appearance is the more usage of the product?
As I reinstated in my opening statement, we only see one person suing our company here today. Is it a coincidence? Obviously not. So answering your question, yes, her usage of her using more than recommended amount on a daily basis for a long period of time is the only cause of this skin disease.
Okay, I'm the only one who sued the company, that is fine. But how do you say only one has been affected by this product? What if some more also have been affected and I'm being representative for all of them? How do you say only one has been affected?
Isn't this
what if more are affected?
Yeah, okay, I'll just rephrase that question. She's saying that if Isha has been affected too, don't you think there are more circumstances of future where more individuals can be affected? I'm just going to rephrase that question for argument's sake here.
Yes. Okay. There are possibilities for everything. When you especially introduce a product that's something that has to do with your body, there can obviously be side effects. But then that's why we have guidelines. That's why we have limitations. You go onto our website, you go onto our advertisements, there are obviously guidelines telling you how much to use, how much not to use. So we as a company believe that our customers can understand those guidelines and we don't have to keep specifying it to them on a daily basis. That's why we have it on the package of the product itself. That doesn't mean that we can go to every customer and tell them use this much, use that much.
Thank you so much. Any other more questions?
No, Your Honor, that's it.
I have one question to each of the plaintiff and the defendant. Defendant, though you have provided me with the case that, hey, there are guidelines for these packages, don't you think there's a problem with your marketing by itself when you're forcing so many individuals to perpetrate for fair and whiteness creams in that?
All I'm going to say is we don't force anyone. Advertising is persuading them. It's not forcing them. And yes, you're right. We may come off as fair and lovely. Okay, we may come off as promoting fairness, but at the end of the day, all we want is the betterment of our customers, the betterment of the people we're reaching out to. And if they don't follow the guidelines we're giving them, I don't know as a company, my defendant, where we can stand on the manufacturing of product.
All right. Okay. Thank you so much.
Your Honor, I just have one more question left. Can I please ask that?
No, I'm so sorry. You can't ask them now. Okay. Plaintiff, I have one question for you. Considering that there has been necessary steps taken by the company in order to avert this, why do you still want to sue the company for this to happen?
My main point here is they are now a wide known company and they should have more precautions when they are representing a huge product like this, and they are influencing many people through their product, that they provide fairness skin as a result of using our product. Then they should have been more careful. They are responsible for each and every person who is using this product. It's not like only one who has happened. That is, she is the only one who is suing me. It's a coincidence. That was all a fact, but they are also responsible for Isha here. So I'm very sure that they have to pay compensation. And there was also a mistake on the part of Isha, but there are also many untaken precautionary measures on the side of the defendant, according to me.
Okay, thank you so much. We will be moving on to the next round. Thank you so much, plaintiff and defendant, for this case. But yeah, just a small note: Fair and Lovely doesn't actually make you fair and lovely. There's been so many cases on the same note, on the same notion. Actually, excellent lawyer up events. I think when I was the 9th grade in my school culturals, this person gave us a wonderful argument why Fair and Lovely should be banned by itself and not just be sued. But yeah, anyways, that's interesting. So we're going to the next 8th round. Could you please tell me the next participant names?
Yes, it will be Prasiddhi from Chinmaya Vidyalaya.
I'm so sorry. Could you please say the name again?
It will be Prasiddhi, if I'm spelling it.
She'll be 4, right?
Yeah, it will be 4. Chinmaya
Okay.
Vidyalaya.
Okay.
And then she's against Daya Shakti. She's going against from National Public School, Indiranagar.
Could you just keep it Daya, please?
Perfect. All right. Okay. I hope you guys have taken enough time to prepare. So I'm just going to say the case again because it's live on YouTube. So I'm going to have to speak because they can't read the Zoom chat. So I'm just going to have to keep saying what the case is. Shini and Boni went to Vista's restaurant for lunch. Shini ordered a drink from a relatively new brand called Cruiser. The waiter, instead of pouring the contents of the drink into a clear glass cup and serving it, gave Shini the can directly. While drinking, Shini finds a dead spider in contents of the can. He also falls sick upon consuming the drink. He sues the restaurant for negligence. So Prasiddhi, you would be Prasiddhi, you'd be representing Shrini, and the Daya, you'd be representing the restaurant. Okay, cool. So whenever you're ready, plaintiff, please go ahead.
Okay, so can I start?
Yeah.
Yeah. So hi, I am going to represent my client, that is Srini, and I would like to say that it is first of all a huge health violation. I have my client has been a very regular customer of this restaurant, and if the the standards have to stoop so low that she finds a dead spider in her drink, I think it is a huge fault on the restaurant's behalf. It is they have to make sure if they are experimenting it with a new brand or with a new drink, they have to make sure that the company's standards are as high as the restaurants. So and especially since my client fell sick, it's not unreasonable to assume that it might not happen again, and the next time it might be worse. Like maybe the drink that they serve has much more worse contents than what they found now. And that's all. I'd like to end that.
Okay. Yeah. Defendant.
Your Honor, may I start?
Yeah.
Okay, presenting my case in 3, 2, 1. Firstly, on behalf of my client, I'm extremely sorry for the poor service that our customer had to experience in the restaurant. But we also believe that we are totally not at fault because it is the brand Cruiser that is to be blamed, and we were nowhere responsible for the unfortunate event. Furthermore, as already mentioned, it is a new company that neither we nor Srini was aware of. But they chose to serve it and we chose to provide it. And furthermore, there was no specification or requirement as to how it had to be served. We had no requirement of serving it in a clear, transparent glass cup. And we chose to serve it in the way they provided it. And it is the brand that was negligent about the cleanliness and hygiene they maintain in their factories or wherever it was manufactured. And because of that, we believe it is the company that has to be sued, the brand Cruiser, and we are not at fault, although we sincerely feel bad for what happened to our customer and for the unfortunate event. Thank you.
Oh, okay, cool. Thank you so much. Could you please go ahead with the questions, defendant?
That's me, right?
Yeah.
Okay. Firstly, why do you choose to sue the restaurant instead of the brand Cruiser, which is actually the one at fault?
Yeah, so I am, so my client is your customer. They did not, when they came to your restaurant, they did not want to, they did not opt to drink from the company that your restaurant has been taking the drink from. Like, why haven't, okay, sorry, that's a question on my behalf. I will be asking that later. Yeah, that's my answer.
Okay, may I go ahead with my second question?
Yeah.
So as you mentioned that we had to be careful about, our client had to be careful about the hygiene standards maintained by the brand Cruiser. It was also Mr. or Miss Srini who chose to purchase the drink, which means they also didn't know about it, but they did choose to buy it. So is it like, it's not just we who are responsible. Our client who's responsible. How do you have to react to that?
So I have, so my client has ordered the drink trusting your restaurant. Okay, so for example, if you order a mocktail, do you go and ask the, restaurant, what brand are you taking it from? You don't go and ask the restaurant that I want it from this specific brand. So my client just asked for a soda, and your restaurant has provided her with that particular can of, I don't know what contents with a dead spider in it. So it's massively a fault on your end.
Yeah, I'm done with my questions. You could go ahead.
Okay, yeah. Plaintiff, your questions?
Yeah, so I would like to ask, why hasn't your, restaurant implemented proper health and safety standards?
Our restaurant has definitely, my client's restaurant has definitely implemented health and safety standards. And what happened was an accident due to the negligence of the brand Cruiser and not ours, and definitely not ours, because we chose to purchase from them and it was a fault on their end and not ours. And if someone had to be sued, it is the company Cruiser and also the government authorities who gave them the permission and license to manufacture the drink, and definitely not the restaurant.
Okay, yeah, your next question, Plaintiff.
Yeah, I'm done with my questions.
Okay, I have one question to ask both the plaintiff and the defendant. Firstly, the defendant is the restaurant, right? Don't you think there is also sufficient responsibility on your way of considering that these items are in your menu? This is with the context. This is with the context that many times, like if you're ordering a Sprite, is always also poured into a cup and given. In that context, don't you think the restaurant also has sufficient responsibility in claiming that in covering damages for such negligence?
We are definitely feeling sorry for what happened, but we don't feel that we are entitled to cover expenses, because firstly, what was ordered was the drink, and secondly, what we served was the drink. There was no specification on how it had to be served, and we just chose to serve it the way we got it. So we believe we are not at fault.
Okay, cool. Yes, plaintiff.
Can I add a point if I can? Okay.
You can't. Okay. Thank you so much, defendant. Plaintiff, why do you want to serve the restaurant? Why do you want to sue the restaurant and not the brand for negligence?
Because when my client chooses to go to the restaurant and order a drink from them, the restaurant is, responsible for what they serve. It's not my client's choice to choose from what company they wanted. If the restaurant has gone and chosen the particular company, they literally represent the company. And obviously, it's their fault for, having ties with the company.
Cool. Okay. Thank you so much. Before going, okay, thank you so much, participants. Who are the next participants?
It will be Mayura.
Which school?
From DAV Girls.
Okay,
and Gaurav from Babaji Vidyashram.
Okay, fine. Just one small thing. When you're giving your opening speeches, right? That is the 90-second speech. You don't have to take the time out and explain the case, because I've already told what's the case to anyone. I just want to say this because I can't exactly rank both the participants or like who beats whom. if you guys don't provide me reasons in those 90 seconds, why is it unjustified? Logical reasons in the 90 seconds, right? Okay, I just want like the future participants to know. But yeah. Yes, anyways, Mayura and Gaurav, are you here?
Yes, I'm here. One second.
Gaurav? Okay, cool. Yeah. So I'm just gonna. I hope that you have taken your time to prepare. I'm gonna read out the case again. Akbar sends Birbal a letter. I'm willing to set my HD 52-inch plasma TV to you for 50,000 rupees. Please reply via SMS with the intentions within the next week. Birbal replies via SMS saying that he was going to buy the TV from Akbar. Unfortunately, attacks break out in Birbal's residence, and the government is forced to disable SMS and other telecom services from the town. Thus, although Birbal sent the message, it failed to reach Akbar. That Akbar didn't receive it, and he proceeds to sell the TV to someone else. Now, once the situation in his town settles down, Birbal finds out about this and sues Akbar for breach of contract. With the facts of the case, Mayura, you would be representing Birbal, and Gaurav would be defending Akbar.
Yes.
Okay, whenever you're ready, please continue.
I would like to start by saying that by the way the Akbar has messaged Birbal saying that please send a confirmation message, we can safely assume that that is the final step for the purchase, which means that all the details have been previously decided upon, and the only step left was confirmation. Though Birbal had the intention of buying and was able to send the message, due to unforeseen circumstances, the message was not received by Akbar, and thus the final confirmation was not received by him. But since all the previous details of the contract has already been finalized, it does not mean that just because the person hasn't received a confirmation, that means they have to look for another buyer. Akbar must also have come to realize the situation Birbal has undergone, and should have waited at least for a couple of more days till the situation gets resolved. And since he hadn't done that and immediately looked for another purchaser and sold it, my client would like to sue Akbar for breach of violation. Yes.
Thank you so much, plaintiff. Defendant?
Yeah. So first of all, Akbar was willing to sell his TV, and Birbal agreed to buy the TV. So now in the area, when there was an emergency, it was not his fault. Like, he didn't know that there was an emergency in his town, so it was not pre-planned. It's all of a sudden. So how do you think he could have decided on a prayer hand? And moreover, Akbar. Yeah, so that's all for my opening right now.
You have a minute more. Are you sure you don't want to say anything else?
Yeah, done. Sure.
Okay. So your questions, please, to the plaintiff whenever you're ready. Defendant.
Okay. Yeah. So first of all, it's an emergency. It's all of a sudden, so it's not pre-planned. And moreover, in an emergency time, like, he may need some money, so that's the reason why he sold. So why do you think selling his TV in such a situation was bad?
As given in the statement, the state of emergency was at the side of Birbal and not Akbar. And since all the terms of the contract had already been only the final confirmation step was left, it is mandatory for Akbar to wait until the situation gets resolved. Just because at least yes.
See, first of all, it's an emergency time. He may be near money. So
the question, or is that all your question?
Yeah.
Cool. Okay. Plaintiff, do you have any questions?
If, as you said, your client was in dire need of money, shouldn't that already been informed to people who is the purchaser that by such and such date you're supposed to pay? Those terms was never ever informed to the client. So how could you say that he was in dire need of money? That's why he sold it before fulfillment of the contract.
Okay, so let's say you have a TV or any product, you're willing to sell, like you won't be like telling them, right? Like, why am I selling this product? It's not of need. Like your point of selling is to get money. That's why you don't have to tell the reason why you're going to selling it, right?
Another question.
Okay.
If you have formed a contract, why do you? What was the necessity for you to breach it?
Okay, yeah, there's a clear up statement. See, again, I'm saying, it's a emergency time, need of money, maybe. It's all based on personal needs, right?
All right. Okay.
That's it.
Okay. Cool. Cool. Thank you so much. We will be going on to the next round. Thank you so much, participants. Who are the next participants? Subsequent round.
It will be Mayura Ellen.
Myra just finished, right? Or is there another one?
No, sorry, 1 second. Sorry. Yeah. Sorry, it will be Sana Rahman from Gil Adarsh. Will be going for.
Could you repeat the name?
Sana Rahman.
Okay.
I'm here.
Yeah, for. And it will be Arjun Ramesh from NPS Indranagar. Will be going again.
Arjun Ramesh, right?
Yeah.
Wait, NPS Indranagar, that is Bangalore.
Yep.
Okay.
So I am for talking for the family of the Clooney.
1 second. 1 second. Have you guys? Is 3 minutes over for them?
Yes.
Are you sure? Okay.
Yeah.
Could the participants please switch on your cameras?
Just a second.
Right. Okay. I'm just going to read out the case again. Clooney and De Niro are two professional wrestlers. They're approached by WWF, a company that sets up and broadcasts wrestling matches around the world. WWF offers the wrestlers $2 million each if they agree to fight with each other in an exhibition match. The wrestlers agree and proceed to train for the match. While training, Clooney suffers a concussion, but decides to hide this from everybody and continues his training. During the match, De Niro slams Clooney to the ground and Clooney is knocked unconscious. There were no immediate medical facilities available at the venue, and so he was taken to the nearby hospital. There he was pronounced dead on arrival. Clooney's family sues the WWF for not having necessary medical facilities. So, in this case, who's the other person? Sana, could you please keep your video turned on?
Yes, just a second.
Cool. Sana would be representing the Clooney family, and Arjun would be representing the Corporation of the World Wrestling, WWF.
Can you see me?
Yes.
Okay.
Remember, you're ready?
So, yes, I'm ready. Can I start?
Yeah.
Okay, so my case is my client Clooney
One
was.
second. Varun, you have to start the timer. Cool. Okay, stop. 1 second. As I said earlier,
I'm so sorry.
Just a second, please wait. Just a second, I'll take my glasses and come. Please wait.
Please take your time. Yeah, I just wanted to say, please skip the niceties. You have only 90 seconds. Use the 90 seconds to say the reasons to do so. That's just easier for me to judge between two participants. Okay, thank you.
I'm here. Hello, can you see me? I'm talking for the Clooney's family, right?
Yeah.
Okay, so can I start?
Yeah, please go ahead.
Okay, so my client Clooney was in a is a professional wrestler and managed by the team WFF wrestling matches all around the world, which is done. So basically, the match started and he was meant to be given 1 million rupees for the match. So he was knocked by the opponent, and suddenly he was unconscious and he was needed medical facilities, and the WFF company was out of medical facilities necessaries, which is a big it's a big problem actually, because they need if it is a wrestling match, and why don't they provide any medical facilities, which is an important thing for the wrestlers. They if someone happens something, it needs some medical facility. Obviously, it's so obvious. Why don't they have some medical facilities or necessaries in the grade WFF company or something? Yeah, that's it.
Thank you so much. Next would be the defendant.
Yeah, sure. Thank you so much, Your Honor. So yeah, we are very aware that the argument by the plaintiff would come out to be really acrimony, would come out with a lot of acrimony, and we don't expect any adulation. We just want the real story to be heard by everyone. Yeah. So, and we just would like to tell the plaintiff that if the plaintiff continues with this line of justification and goes on further, we'll be countersuing for defamation, and we really feel that this case should be thrown out of the room and dismissed immediately, because this is a complete breach in contract, as he didn't inform us of anything. And if he was still alive, we would have terminated him immediately, because as I said, it's a breach in contract. He didn't inform us. He didn't properly follow the guidelines of our contract, stating that if he is mentally or physically hurt, he should be informing the things. So that's a complete breach of contract, and we can't be held liable for that. And secondly, also the contract gives full medical care to the wrestlers, and this wrestler didn't get informers. So, and also one more thing, when even before wrestling match, the wrestlers are asked if they are okay for the match, if they are ready, and even before the match, he said nothing of that sort. So we don't know. We're not paying a single penny for lapse in judgment by anything. And if this is a silly way of the family to get any money back, sorry, we ain't getting into that sort of line. We are a big company, and we can't be put into such petty cases because of attention seeking and financial needs by these families. As we clearly state, there's a lot of breach in contract here, and we'll countersue for defamation if this continues. Thank you. Your Honor, you're muted.
I'm so sorry. Thank you so much, defendant. You'll be proceeding with the questions that you can ask to the plaintiff.
So plaintiff, in the termination contract, it clearly states that if you inadequately completely perform in any of his duties, or if he fails to follow the direction of the WWF officers, or he becomes incapacitated due to physical or mental injury. So how are we liable if he's going to go against all these rules?
Yes, I agree that he was not well at that time, but still, you guys have to provide all the necessary facilities that a wrestler needs when he is knocked out or needs some, if it's hurt, he needs some medical necessary. Why are you not providing all this? And this is, no, you can't completely put the blame on my client, because it's a completely, it states that he died because of if he would have got the facilities earlier, like in some time by the company itself, he would have been alive right here. But unfortunately, he was not, because of your carelessness. That big company has provided the bad facilities. Like, are you even serious? Like, that big company doesn't have some medical facilities?
Okay, please do not use statements like that. You guys are imitating real-time lawyers here at court. Please maintain formal decorum. Right. Okay.
Yeah.
Defendant, could you please go to the next question?
Yeah. Plaintiff, you do realize that even in a medical testing center, before the people are tested, they ask if you have any prior condition. here this person hasn't had any condition. How are we supposed to know? And at the wrestling center, we all have proper proper healthcare officers for certain needs. We don't have it going all the way where you have brain damage and they can't handle it. So I would like to just ask you, how are we supposed to handle a situation when we had no awareness about this condition, and why should we take action and give attention to such a case where as I said, we didn't have anything, and be very careful of what you say, because we would be countersuing for defamation if we didn't say anything that's harmful to our reputation.
So it doesn't say he has a brain tumor or some other thing. It was definitely the company's fault for not having some medical facility at the earliest. But also, why can't you compensate the $2 million as said? And first of all, it's a very waste and shame on you people that there is no medical facilities in such a big company. And that's my answer. And it's completely my opponent's fault and not my client's. That's it. Next question.
Follow up?
No, just you have one more question, I think.
That's like a logical fallacy right there.
I can't, I'm not going to say anything. I'm taking note of all your questions and your answers.
Yeah, sure.
Okay, cool. Plaintiff, your question.
Yeah, my question is, it's such a big company as said by the opponent. So why don't such a big company has a medical facilities for the wrestlers? You are providing such $1 million for the clients like wrestlers if they do the match, but can't a simple medical facilities be there for the wrestlers?
Your question, please. Please stop referring to rhetoric.
My question is, why
Simple
don't
logical question and logical answer to be followed. Okay.
My question is, why don't such a big company has a medical facilities? That's my question.
As you said in your question, why doesn't such a big company have simple medical facilities? Simple next thing. So you do realize that simple medical facilities can't tend to a person with a concussion being knocked out, right? Whenever there's a wrestling match, we do have adequate medical officers there to deal with such a, suppose a person's knocked out, to check if they have a concussion. But if you already have a concussion and you're knocked out, that does serious damage to your brain, and normal medical officers who are present next to the ring can't handle that. So what you're saying is absolute nonsense, and we are not obliged to have such officers there.
Please just
maintain. It's not nonsense.
Yeah. Okay.
Can I follow?
Take a step back. Take a second.
Okay. So next question. My next question.
Take a breather. Just 5 seconds. Okay. 5 seconds. Don't say anything.
So can I ask my next question? Okay.
Cool. Right. You guys are not 16-year-olds. You guys are lawyers with law degrees at court. Just saying. Cool.
Just saying nonsense is allowed at court. Yes.
I'm pretty sure they don't do that in bilateral discussions. Okay. Cool. But yeah. Yes. Your next question, plaintiff.
Okay, so my next question is, as said, $2 million for doing the wrestlers, but why don't they compensate the death family? Because it's such a big loss to their family. They lost a family member. So why don't the big company provide compensation to the client?
Okay, I'm just gonna stop you right there. The case is about suing WWE for not having necessary medical facilities. Okay.
Yeah.
Could ask another question. It'll be great too.
Yeah. My next question will be like, I want to sue you because of your irresponsible and carelessness of the company, and my client died because of that, and you can't put a blame on the sickness or something. And my question will be, just a second.
It's all right if you don't have a question. Also.
Can we have closing statements?
I'm done.
No, we'll be maybe having that for finals. But yeah, okay, cool. Thank you so much for both the participants. I have one question to both the participants actually.
Yeah,
firstly, it's to the defendant. Defendant, don't you think in the same scenario of having necessary medical facilities that one second, yeah. In a boxing match, don't you think there would be enough? Don't you think there should be enough medical facilities for even to take care of a person being unconscious, regardless if he had a concussion or not?
I'll give you an example, please. In let's say a cricket match, someone already has like a concussion, ball comes and hits them on the head. They have severe brain bleeding. I'm sure our Indian physiotherapist can't, our Indian physio can't handle brain damage or brain bleeding, such stuff like that. So obviously we don't have facilities to deal with injuries that are not natural to what happened in a boxing match, because those stuff can't happen. Right. And regarding to what the plaintiff was saying about us giving the money, that isn't going to happen in any scenario. What's going to happen is you're going to pay us money because we're going to sue for breach of contract, defamation of counter sue for defamation. So you better be ready for that, because it's going to be much more than $2 million.
We are talking about a boxing match.
Yeah.
Boxing match, and I don't think it's quite fair to equate to a cricket match.
Yeah,
right?
but I'm just talking. Imagine you already have a concussion, and on top of that, you get knocked down. I'm really sorry to Miss Clooney's family, but yeah, he got knocked down. But so if you get knocked down, that's going to be brain bleeding or so many other stuff that happens in your brain that can't be handled by normal doctors who are going to be on ringside.
Cool. That's all I wanted. Okay. Thank you so much. Plaintiff, don't you think there's more on a wrong on your behalf, being in the Clooney family, to not inform the authorities of a concussion? Why do you think why do you think it's rather a fault of having less medical facilities than him not reporting to the authority itself? In your reasoning.
Yeah. Okay, let it be. My client is already sick or suffering from some other thing. Let it be. But can't they still provide the facility? If he would have got the medical necessity at that particular time, he would have been alive. That's what my answer will be. And why it's such a shame that such a big company doesn't have a medical necessity to for their own wrestlers to make them alive. Like, it's such a shame to tell that someone died because of non-medical facilities. I can't even imagine. Like,
okay. No. Thank you so much, participants.
I would just like to say that he broke contract the minute he hit the thing from us, so we owe nothing.
Okay, thank you so much. We'll be going to the next round. Could you just tell me the next part of it? Thank you so much.
Sure, it will be Varnika from PFBB Millennium.
Could you please state the question name again?
Varnika
from Millennium and
then it will be Kanika Shivapal from National Academy.
Okay. Could you please state? Okay. Cool.
Yeah.
Okay.
Kanika will be going against, and Varnika will be going for.
I'm going to just state the case again. So Kim has a severe infection in her gallbladder. She learns about this from Aries Hospital, who also tells her that the infection could be deadly. The best way of stopping it was to remove the bladder itself. Kim agrees and signs the contract with the hospital for the necessary surgery. The surgery is successful. After removing the bladder, Aries Hospital conducts tests on her and utilizes contents from the bladder to create a new drug for combating the infection Kim had suffering from. They patent it and sell the drug, making huge profits. Kim learns about it and sues the company and asks for her claim of share in the profits for the sale of the drug. Now, Varnika, you'd be representing Kim, and Kanika, you'd be representing the hospital. All right? Okay, so you can start whenever you're ready.
Am I audible?
A bit. Could you just be a little louder?
Yeah. Am I audible?
Yeah, better. Thank you.
Okay, cool. So my client Kim. Okay, so firstly, the contract only stated for him getting a surgery, and my client has only signed for that. There is nowhere in the contract mentioned that his contents or the contents from the bladder are going to be used to make a drug that's going to have its own beneficial purposes, and she wasn't even informed about it, which is not only it's basically invasion of privacy, and without her consent they took it away. And secondly, when they made huge profits from the given vaccine or whatever they found out, it's only fair when my client gets a fair amount of money or claims from that profit that they've made, only because it's my client's
contents from the bladder, and thus it belongs to her, though it's given to the hospital. And taking consent and making her sign a contract would only make sense, and it would be fair, considering it does not belong to the hospital and it clearly belongs to my client. And we would like to sue the hospital for invasion of privacy and not giving her fair profits in the whole profit. I would like to conclude my case.
Cool. Thank you so much, Plaintiff. Defendant, whenever you're ready.
Yes. Good morning. My client as hospital, the defendant here, is being sued on the grounds that the quote-unquote stolen, that we have stolen from the plaintiff who came to us with a rare gallbladder infection, which we successfully resolved as of today. It is important to note that the plaintiff Kim had no involvement in the development and production of the drug. We wouldn't have had this life-saving drug if it weren't for the tests conducted by our research team. And according to our tests, we would have found this drug if it weren't for the research team, and it had no prior information provided directly from Kim. And we therefore hold our research team accountable for creating this drug and not Kim. Thank you.
Thank you so much, Defendant. Could you please proceed with the questions to the plaintiff?
Yes. So the plaintiff said that in the contract, they were, I quote unquote, or you said that there was no consent to take it away. So if you're referring to the gallbladder, then yes, there was consent taken from the patient, Kim, to perform the surgery. So would you like to rephrase that? Or
No, it's not a question. Could you please rephrase it as a question?
Okay. So in the contract, they were mentioned of usage of the gallbladder that's being extracted. So so on what grounds do your patient hold this against us, as it was mentioned clearly in the consent?
May I go ahead?
Yeah.
So I, which is the plaintiff, remembers saying on the exact words along these lines, saying that the contract was signed to take the gallbladder. Yes, the plaintiff is not denying that, but on the other hand, it wasn't asked, or it wasn't asked from my client as to whether they can use the removal that was taken from the hospital. Thus, without my client's consent, the hospital cannot and should not use the removal taken from my client's bladder to form a drug. And I would also like to mention that my client or the plaintiff is not denying that she was saved because of your hospital. Yes, she was saved because of hospital. But the other hand, your hospital does not have any authority to take someone else's biological material, let it be waste or anything, and use it for the benefit of your own thing.
Okay.
Okay.
Next question.
Okay, so the next question is, do you view this life-saving drug as a benefit to the entire hospital or the welfare of the people?
Well, we do look at in the benefit of the entire, like in a global perspective, but we cannot deny the fact that any hospital would just make a drug and just only think about the people, because in the end of the day, it's a private hospital that would only look at their own profits. And on the other hand, we are not saying whether you guys are just taking all the money for your own cost. At the end of the day, yes, you guys have done a good thing, probably you have a good motive. But on the other hand, without taking my client's consent, you guys have done, your client has done something that would, and you cannot deny that. So it's only fair if my client gets a fair amount and should get her share of deal in the profits you guys make.
Okay. So
you have one more question, Defendant?
Yes, one last question.
Please go ahead.
After the surgery, the patient didn't ask for the gallbladder back, and there's no law stating that you can't keep an organ even though it's considered unorthodox.
What's your question?
So if you're asking for the shares, why didn't you ask back for the gallbladder as soon as the surgery got over?
So are you implying or are you blaming my client to trust the hospital that saved his life simply because
Sorry, could you please not replace the question? I think the question was pretty straightforward. I'm going to ask you to repeat the question one more time. Could you just repeat just the question, Alun?
Yeah. So if you wanted the profits of if you're taking the factor of owning someone else's biological parts, then why didn't the plaintiff Kim ask back for the gallbladder if they didn't want the hospital to do any tests on it?
Right. So the test was taken without my clients knowing. A, B, the defendant is accusing my client of simply trusting the hospital as to they wouldn't do anything with the bladder or whatever they're going to contain. So I don't think so it's my client's fault and my client being innocent here to know that the hospital would misuse his biological materials to find something, though let it be for a good cause, but without her consent. Her consent is what matters here.
Okay, thank you so much. Plaintiff, could you please go ahead with your questions to the defendant?
So my first question is going to be, your client or the hospital has claimed to have good motives behind this whole forming of drug for the global perspective and to help of people, right? So why didn't the hospital simply take my client's permission or consent and go ahead with the whole project? Why would they choose not to take my client's consent, go behind her back, and then do this project if it was for a global cause?
Okay, so first of all, after the surgery is done, the remainings can be considered as part of the hospital's property, and we as researchers have authority to to do our tests on it. And if you are asking on going behind Kim's back, well, our only intention was to find something that would help cure this or prepare a life-saving drug.
Right.
And
so you claimed that
question.
Okay,
question.
so the hospital claims that the biological material left is in the hospital's property, and you simply researched and went ahead. Okay, after the hospital found out that this is a life-saving drug, why wouldn't you get back to the person who it belongs to and ask? Why wouldn't you do that? Because in the end, if it's for a global cause and it's for the global perspective, after finding out the drug and you know it's successful, why wouldn't you go back to the person and ask them for their consent of having it used?
As I mentioned in my opening statement, it's because Kim did not get involved or help in the production, research, or development of this life-saving drug. And it was all completely the faculty of our hospital.
Right. So how is it on my client not having to know that that the hospital is going to create some drug, and my client who's simply a patient of not having any scientific knowledge? Yeah. So how do you expect and how do you think it is on my client to not having known about the whole process of the hospital making drug and her?
Sorry, I don't get your question. What is your question? Why
Question is,
you're asking the hospital? Why doesn't your client know that this is normal procedure?
I'm just trying to imply that my client wasn't known of the entire process and found out about the drug later. So
could you just ask a question that she can answer? Because these are like, if you're implying stuff should be in your opening speech, right?
Okay.
Yeah.
So how do you expect my client to, having known the entire process of the drug when she wasn't even informed and she figured it out later?
Okay. So what I got from the question is, you wanted us to tell Kim that we were performing these tests on the gallbladder? Is that your question? I'm just trying to...
I'm not going to explain the question. Just answer whatever what are you interpreted from that question.
Okay, so our hospital carries out millions of tests every day, and and some of them fail and some of them succeed. So like the ones that we got right now, the life-saving drug, it succeeded. So I don't see the necessity of explaining each tests or processes that we conduct in our hospital to an external source, because it has the research and development team.
I'm just going to ask both of you one question. I want to give you guys 30 seconds or 25 seconds only to answer. All right? Do you think, as lawyers, that A, the gallbladder, the post the gallbladder that the patient has consented for to remove is needed permission from the patient or hospital's property? Okay, I just want you to guys think about this and answer in 20 seconds only. Right, Plaintiff? Do you think the gallbladder that has been removed is the property of the patient, or that she can still consent to, or is it left to the discretion of the hospital? Just this entire point. Okay, just answer. Plaintiff?
Yeah. So I think it belongs to my client, which here being the patient. And
okay, why so? I want you guys say what? Say the statement and like why.
Why? Because my client has only signed up the contract for removal of gallbladder, but not for having it given to the hospital. So it belongs to my client, and whatever is done with the gallbladder should be informed to my client, and without my client knowing into experiments or any kind of researches on it, my client should be aware. If as the hospital claims it's for the global cause, a wider perspective, then my client should be aware because it's basic rights, because of the basic rights she owns.
Okay, cool. Defendant, why do you think so? The reason and so on.
Okay, so we believe that after the surgery, the remaining properties of the hospital, unless the client asks for it, which in this case is not being done. So therefore, it's presumed that it belongs to the hospital. And once it's with the hospital, we are not with the profit motive, but welfare motive of always doing research and finding life-saving drugs. We shall do whatever we can with our power to improve in technology and save as many lives as possible, similar to Kim's.
So, okay. Thank you so much. Thank you so much. Varun, could you please let me... Oh, thank you so much. We'll be going to the next round. How many rounds are left?
So the prelims are over right now. You should be watching the top four.
One more, right?
One more participant, yeah.
Oh, sorry, my bad.
Cool. It's all good. So this is the last round of the prelims, right?
Yes.
Cool. So could we have the last round, the participants?
It'll be Shiraja from PS Senior. And
could you please turn on your video? Shiraja, is that right?
Yeah, Shiraja from PSBB,
yes.
and Chirag from NPS International Mysore.
Wait, Shiraja and Chirag?
Yes.
If I'm not wrong, was there another Chirag? Okay, cool.
No.
Cool. Okay. Yeah. So I hope you have time to prepare. I'm just going to read out the case again for anyone who's seeing this on YouTube. But yeah, Ajit Kant, a politician, is accused of corruption and is going to be tried in court. GG News channel invites him on their show a week before trial. He accepts and appears on the show. While on air, the host repeatedly calls him a cheat and a scoundrel. The trial then proceeds and is acquitted of all charges. Ajit Kant now sues GG News channel for defamation. Now, because if Shiraja was talking for, she should be representing Ajit Kant, and Chirag would be representing GG News Channel, defending GG News Channel. Whenever you're ready.
Okay, I like to start. Okay, so GG News Channel invited Ajit Kant a week before his trial, and they went on to call him a cheat and a scoundrel. First of all, I think it's highly unprofessional to call a politician a cheat or a scoundrel, irrespective of whether he's been accused of corruption. And also, it's very. We also think that it's highly unprofessional of them to accuse him of corruption and go on and call him a cheat and scoundrel when the outcome hasn't even come off yet. The trial is in a week, and they have no rights to even comment on what's going on, and comment on it, and leading up to calling him a cheat and a scoundrel when nothing has been proven. And when the outcome wasn't even out, the TV show, basically the hosts have no right to call him anything. And now that he's been proven innocent, now it's known that he's been proven innocent, although they kept calling him a cheat and a scoundrel. So what they're saying is factually inaccurate and also highly unprofessional of them to do so. Now that we know that GG News Channel has a good number of viewership, the hosts calling him a cheat and a scoundrel basically ruins Ajit Kant's reputation as a whole. So what we can infer from this is, I mean, when they called him a week before trial to just call him a cheat and a scoundrel in a TV show, which is basically them wanting to defame him.
Thank you so much. Next, we'll be going to the defendant.
Thank you, Your Honor. First, I would like to take up a point. Politician, when he was accused, in the first he was accused of corruption, but we did not accuse him. So when we invited him for the air show a week before, he should have. I'm sorry, 1 second.
Okay, when we just start the speech from start. Okay,
yeah.
Just reset the time.
I'm sorry.
All right, no problem.
Okay, I can.
Yeah, please go ahead.
Okay. The politician was accused for corruption, which we don't know who did. And one week before the trial, he was invited to the air show. If there was a news about his corruption, he shouldn't have attended. We just invited him, not forced him, and we asked him if he can come to the show. It was his choice that if he would have come or not. Though we accept a mistake that we shouldn't have called him with names, but when they were criticizing him over there by calling him cheat and all, why did not defend himself on the air? One point I would like to ask, and afterwards there was a 1 week time before the trial. So when there was an accusation of corruption and on the air they were calling him a cheat and scoundrel, why did not he defend himself at that point of time on the air if he did not do it? This is my opening statement for now.
Okay, just telling anyone, I don't know why people think these are opening statements, but there's no closing statement. So this is your only statements, right? So, okay, anyways, right, we can moving on to the questions. Defendant, if you have any.
I have one question.
Yeah, please go ahead.
Yeah, thank you. So, if there was an accusation of corruption, he was still called for the trial to the court, and putting him down to his reputation. The trial also means that he's done something wrong. That's why there was been a trial with some evidence. Maybe that evidence were not up to the mark or something, or it was not able to be proven in the court. But he was asked to come for the trial, and this is one of my questions. So if he did not do anything, he should have said on the air when we were criticizing when the channel was calling him cheat or scoundrel.
Can I answer? Okay. First of all, he cannot possibly defend himself in that talk show because he still has a trial to go for. He cannot call himself innocent because if he, after a week, if he ends up being proven guilty, it's ruining more of his reputation. And it is, I'm pretty sure it's not legally right of him to comment about it or take sides on it when it's not his trial and when it's a talk show. Secondly, your question, I believe the first part of your question was why, is there more of a question? I'm sorry, I was focusing on the second part.
Could you please repeat that, Chirag, if that's okay?
Yeah, it's okay. My question was, he had been accused for corruption, and that time they asked him for a trial. So there must be something that he has done it. That's why he's been called for trial to the court. So if he, I cannot frame it properly in that way.
First of all, yeah, I understand. I got it. First of all, there is no reason for him to have done something wrong to be there. He might have been a witness in a situation where, he might also be one of the cases. You can't just assume what the case was and comment on him being guilty or him doing something that makes him guilty. He might have just been a witness or one of the witness's friends or one of the guilty's friends or the innocent person's friend. So I don't think that really stands for that really makes you right for calling him a fraud or a cheat in your show.
Your Honor, can I go with my second question? My second question is, he got to know that he's been accused for corruption. So why did he accept the invite from our channel? Because
okay. Yeah, are you done with your question?
Yeah,
you can go ahead.
Okay. Talk shows are not held to call someone a cheat and a scoundrel. It's basically to have a conversation, basically to have an interview, asking people about their questions. As a talk show, you have the right to question him about his trial, but not call him a cheat and a scoundrel. So there is no, I mean, that question doesn't hold any value here, because you called him as you didn't call him to basically defame him. You called him to have an interview with him, which is what a talk show host does.
I would like to go with my third question. So during the talk show, if it's for an interview for a normal talk show, when the interviewer called him cheat or any of with scoundrel, he should have at least tried to say that he did not do anything. That time he did not give any, he did not defend himself or did not agree with it. So there must be something that he was trying. He had something else with it, because he did not say anything to reply.
As I've already responded.
Please, let him finish.
Okay.
No, I'm done. She understood.
Okay, fine.
Yeah. As I've already mentioned in as my first reply to your first question, he cannot basically defend himself there. He has a trial in a week, and he's going to a court and having a trial. It's a huge deal. It's a legal procedure. He cannot call himself innocent or guilty in that situation, because if also consider the fact that you calling him going up and saying, hey, I'm not a cheat and a scoundrel, and him being proven guilty a week later would probably ruin his reputation as a politician more. He cannot possibly comment there.
Okay, cool. Thank you so much, participants. That concludes the prelims of the event Lawyer Up. Give us 5 to 10 minutes. We'll tell you the top 8 finalists, the top 8 participants will be moving to the final.
I have a question. Am I not allowed to question him?
Oh, I'm so sorry. Yeah, I'm so sorry.
Yeah, that's good. Yeah, okay. So I have a question. You in your argument, you had stated that you guys did not accuse him of corruption. But if you didn't accuse him of corruption, but you straight up just called him a cheat and a scoundrel. How is this better than just accusing him? And how is this basically not accusing him of being a cheat and a scoundrel when it hasn't been proven so?
Can I answer, Your Honor? Thank you. We did not accuse him, and second, when he hasn't done anything, why would he be guilty about it? And 1 second, sorry, my fault. I'm trying to. Can you repeat your question? The second part of your question.
Sure. So you said that you didn't accuse him of causing corruption or anything, but you just straight up called him a cheat and a scoundrel in your talk show. How is this not accusing him of being a cheat and a scoundrel, and also assuming that he is one even when he hasn't been proven as one?
for the talk show, the one thing is, in an interview things might go wrong, but in interview there will be an arguments, there'll be ways of talking, and when we didn't accuse him for corruption, the interviewer called him cheat, but not specifically on what he said. There was no points that he said for him to defend him.
Can I ask him a question based on that?
Yeah, sure. You have two more questions. You can ask it however you want.
Okay. Just because he hasn't responded to your accusation as a cheat and a scoundrel doesn't really allow you to call anyone a cheat and a scoundrel in a talk show, especially with a politician. How would you like to respond to that?
Okay. When he's being called for trial, that means I'll get this. I'll get the point clear. When he's called for the interview, he has to accept if he has to go or not. But when he comes to the interview, he's been called cheat or anything. When someone tells you have done something wrong, you have to defend yourself. You have to say that I haven't done anything. You have to at least tell that you have not done at least. But he did not say anything during the talk show, and after 1 week of trial, he's been disowned by all the charges. So why can't he prove that time before 1 week of the court if he knew he didn't do anything wrong?
I think that's all.
Okay. Cool. Just one question to the plaintiff. Considering that plaintiff, right? Yeah. Considering that there's a reasonable possibility of this proceeding to happen in a talk show. Why did Ajit can't proceed with the same?
Ajit was, I mean, yes, we understand that because he has been accused and like he's been called for a talk show, there would be some sort of a talk or a conversation about this. But I don't think it's, I mean, the things that we have expected is something like, hey, what happened? Or, hey, are you guilty? Not, hey, you're a cheat, or hey, you're a scoundrel. I don't think that's something that happens in a talk show.
Cool. Okay. Thank you so much. Yeah. So I think you could, all the participants give to like around 5 to 10 minutes. We'll come out with the top 8 participants who will be moving on to the finals in just 5 to 10 minutes. Okay. Thank you.
Excuse me.
Yeah.
Thank you.
Will you please? I want to talk to Varun. I am from NPS side.
Oh, okay. Yes. Sure.
Varun.
Sir, I've taken care, sir.
No, will you please answer my mobile?
Yes, sir.
Or will you call me right now?
I'll call, sir.
Please call me. Thank you.
Do we have to leave the meeting and rejoin in another 10 minutes?
No. Please stay in the meeting. I'll just.
When will the finals be conducted?
Right now?
In 5 to 10 minutes.
Okay, thank you.
Oh, and it's the same format as prelims.
We'll let the finalists know about that. Okay. Okay. Since Varun, that is Sai, are you here?
Yes.
Okay. Cool. Is it all right if I take 5 to 10 minutes and to tell you like the finalist name?
Sure. You can just message
And
me.
do I have to say it in the Excel sheet that you've given it to me?
No. You can actually message me and we can decide the team up. I mean, whom they're going against, and then we can inform them. You can message me.
Okay. Hi, I hope all the participants are here. Well, yeah, so I'm terribly sorry. Apparently, we are on a considerable time constraint, and this Zoom link needs to be used for another event. So I'll be reducing the top finalists to be 6 people to have 3 rounds, and I don't think there'll be any modification of having closing statement, opening statement, finals, because this event was supposed to be over at 11 and it's 12:20. So I'm just going to be as fast as possible. But thank you so much for participating and coming out to Impressionz Lawyers of Prelim 2021. We hope you had a fantastic time. Without further ado, I'm just going to see the top 6 finalists, and I'll just tell you in what parameters these people have been selected. Firstly, is using the speech to put forward logical reasoning and coming up with a repository of reasoning that can be used in your questioning as well, and your spontaneous responses and your questioning abilities. I'll be telling this in further because we really don't have time right now. So without that, I'm not sure of the schools. Maybe Varun and Sai could help me out, but I have the names. It's Tushya, Tarun, Rajat, Sai Vaishnavi, Manan, Kshiraja. If you Varun and Sai, if you have the names of these schools, could you just let me know?
Sorry, can you repeat the names?
Yeah, but this is Tushya Jain, I think, from Sindhi Memorial.
Okay.
Wait 1 second, I'll just open the Excel sheet. I think the names are there. Tushya Jain, Sindhi Model Senior Secondary School.
Yes.
Next, in no particular order, these are Tarun, Chinmaya Vidyalaya, Taylors Road. Next, Rajat S, National Academy for Learning. Sai Vaishnavi.
She is Saraswati Vidyalaya
Senior Secondary School. Manan, Kola Saraswati Vaishnavi Senior Secondary School. Shiraja, PS Senior Secondary School. Thank you for every other participant. I'm just going to give 2 honorary mentions because to the 7th and the 8th in no particular order. That is to Arjun and Niranjana. You guys almost made it, but great show. But regardless of all the participants, it was a great show to come up with spontaneous reasoning, just being 16 and 17-year-olds, because these are the types of cases we usually moot at law school levels. But yeah, thank you so much for participating. So without further, we'll be moving on to the finals of Lawyer Up Impressionz 2021. I'm just gonna tell you the matchups now. It's Sai Vaishnavi Kshiraja